I think we can see when he gets here if there's a convenient break in the evidence. But 11 o'clock sounds about right, yeah.
And is the intention then, obviously there's preliminary matters to be dealt with, are you then going to start dealing with conditions? Because I think that's the only other business.
That's right, yes. Yes. I was just aware that Mr. Trinnick and Mr. Brown had a point, and I was going to go on to the order for today after that.
Sorry,
Mr. Steele.
Sorry, apologies.
Mr. Trinnick.
Thank you, sir. Kirsty sent an email last night which briefed you on the topic to be addressed, which is the supplementary guidance. And we've had a response from Murray indicating Mr. Brown is ready to talk about this morning. That's good. My starting point is the precognition of Mr. Templeton at 3.3, where he acknowledges that there's a need to, quotes, reconsult on the guidance and submit it once again to the Scottish Government in order for the guidance to be statutory, for part of MDLP 2020, and he tells us something about process. Now, we know that the supplementary guidance is currently, shall we say, bereft of life. Indeed, if Murray Council hadn't tried to nail it to its perch, it would be pushing up the daisies and join the choir invisible. But they are trying to revive this document. We know, and you've got a copy of the report to committee for the 15th of September. It's proposed the Council will grant delegated authority to the Head of Economic Growth and Development, I understand that is Mr. Templeton, to do what is necessary to reissue the supplementary guidance on, and we have the date in the report, 21st of September. And if we look at the report, if you've got it in front of you, we can see the recommendation in paragraph 2.1, which I've already recorded in what I've just said. But if we turn over the page, we see that the intention is that the Murray under 4.1 in the box, third down, onshore wind energy policy guidance, says including the LCS, curious, but there we are. The intention is to delegate, third column, authority for minor changes, such as new cover, update policy references, ensure consistent referencing with landscape capacity study, and include spatial framework following SPP 161. Approve as non-statutory supplementary guidance as of 21 September, and then between September and January to report updated guidance, I assume the one adopted in September as non-statutory guidance, to committee, followed by public consultation and submission to Scottish ministers for adoption as supplementary guidance. Of course, this doesn't just apply to the wind energy policy guidance, but there's another document in play at this inquiry, the Murray Forestry and Woodland Strategy, which comes into the same category as being currently defunct. Now, my point primarily is that if the intention is to adopt this document, in detail presumably, by 21 September, Mr. Templeton must by now know the intended content of the initially non-statutory SG. If not, there are some big questions to ask. It's clear you will need to take account of the contents of the new, revived, resurrected, whatever, non-statutory guidance, and perhaps ultimately the statutory guidance, if that's what they bring forward. I won't submit now on Section 22 of the 1997 Act, the intended repeal of that under Section 9 of the 2019 Act. I will in due course, I don't need to this morning. In my view, the content of this draft must have been prepared, should be before the inquiry. That raises a timing issue because Mr. Templeton gives evidence last. And if he only reveals this content then, it's far too late to put that content to my own witnesses, and the same would apply, I assume, to Mr. Steele and his witness. And so my request is that Mr. Templeton should reveal to the inquiry by email today, that's late enough, the intended content of the non-statutory guidance. Another issue arises separately, that it is claimed that this can be done under delegated authority. Now, our understanding of the Murray Standing Orders is that they do not give officers the power to make policy, to write it, to issue it. That emphasises my principal point. That document must have been prepared to be brought before the members for approval in detail next Monday at the meeting. And if it's nevertheless claimed that there are standing orders which enable Mr Templeton not only to write policy but then to issue it without further reference to the members, we need to know. And I therefore seek clarification on that question also. I really hope that we don't get a "we'll come back to you later" type reply. It's too late for that. The Council must know this would have been raised, and I expect, therefore, to receive a definitive response now and the document so that we can consider it in our own evidence. Thank you.
Mr. Brown.
Yes, thank you, sir. Before I turn to the substance of this matter, I would like to just remind ourselves of the context of this discussion. The matter was referred to by Mr Trinick yesterday morning, and I said I would take instructions on it. And indeed, I spoke to Mr Trinick at one of the breaks to confirm that I would do so later in the afternoon when yesterday's session had finished. And unless I was to take instructions by telepathy, I don't see how I could have taken instructions any sooner than that. Those instructions were taken, and I'm disappointed that this matter may have been presented in a way which creates an air of suspicion as to what the Council was doing. The Council was being perfectly straightforward when I said instructions would be sought and they were obtained. Anyway, we are where we are on it, but the important point is that it was always my intention to raise this matter this morning before business began, because obviously this is the last day the inquiry sits before we turn to consider policy issues next week. So far as the proposal which has been put to the committee next week is concerned, it's recognised that there is an unfortunate coincidence of timing here, but Tuesday's meeting, or next Tuesday's meeting of the Planning and Regulatory Services Committee is the earliest committee meeting at which the Council could consider the supplementary guidance. And of course, the Council or the committee is being asked to endorse updated guidance on the basis that it's on a without, or for the avoidance of doubt, basis as to the status of the guidance which already exists. I appreciate that the existing guidance has lost its connection with the local plan, but that's not to say that it might not still continue as non-statutory guidance. But in an attempt to avoid a debate about that particular point, the intention of the Council is that the committee should consider an updated version of the guidance. There's a technical but nonetheless important point in all of this, and that is, of course, that until the committee agrees the proposal which has been put to it, Mr Templeton is not actually able to say what the Council's position is. Now, there is no prejudice to either of the applicants in the meantime, because as the report to the committee makes clear, and Mr Trinick has already referred to this, the intention is that delegated authority will be given for minor changes, such as a new cover, and that means nothing more than the cover sheet for the document, as I understand it, updating policy references to make sure that there are references to the appropriate policies in the new local plan, and to ensure consistent referencing with landscape capacity study, including the spatial framework following SPP paragraph 161. The fact of the matter is that a document is not available today which can be given to the applicants, which sets out the Council's position on this. The Council first has to agree its position, at which point an update will be made to the guidance. So far as reporting to the inquiry what the Council has agreed to do, it did occur to me that one way to deal with that would be for a supplementary recognition to be done by Mr Templeton, and that could be lodged immediately after the committee meeting, by which point we will know what the Council's position, or the committee's position, and indeed the Council's position is on the matter. But until we get to the committee meeting, it's just simply not possible nor appropriate to lodge a document which does not reflect the Council's final agreed position on this matter. And as I said at the start, I appreciate there's an unfortunate coincidence of timing in all of this, but the Council is doing its best to navigate its way through the issues which have arisen. There's also a supplementary point, and that is Mr Templeton, in his report at paragraph 311.3, refers to the regional spatial strategy and the fact that it's going before the committee on Tuesday as well for consideration. Given that he's referred to that in his report, I would seek leave to lodge the report which he has prepared for the committee, so that that is before the inquiry and can be the subject of his evidence next week as well. But I appreciate that's a less significant point than the issue of the supplementary guidance at the moment.
Were you going to say something, go on about to the point about the standing orders, Mr. Brown?
Yes, I was just checking, sir, to see whether I have a message from my team on that, and I don't have anything yet on that. Oh, sorry, I do. If I may just have a moment, sir, to read that.
Of course.
Yeah. Yes, I'm told, sir, by the Head of Legal Services that she is satisfied that the Council can delegate power to officers to make changes to the guidance. And just for the record, I should say that the Head of Economic Growth and Development, to whom the power is to be delegated, is in fact Jim Grant rather than Mr Templeton.
Is it power to make these changes, the proposed changes in the report, or power to make changes generally?
Well, sir, to be honest, I don't have the detail of that, but the way this message is framed, it appears to be power to make changes in general.
So there's no report going to committee with the form of the proposed guidance, simply the report that's been produced?
It's simply the report which has been produced, sir, because, of course, the report has been prepared on the basis that the changes to the supplementary guidance, once approval has been given to the Head of Economic Growth and Development, those changes will be made very quickly so that the document is available by the 21st of September.
Mr. Trinnick.
Well, so a couple of questions. Has Mr Templeton actually written the document, point one? Never mind it's going before the committee or not. If it's going to be adopted on the 21st of September, I find it very hard to believe there's not a draft in existence for approval by the committee or for the approval by Mr Templeton under delegated powers. Secondly, proposed positions of officers are often put before the committee and appear in committee papers published a week in advance. There's no secrecy about this, and therefore there is absolutely no reason why Mr Templeton's position should not be revealed to this inquiry now. There's no secrecy about the matter, and there should not be. We need to know in time for the evidence. Otherwise, it gives rise to other problems, as the reporters know. And if we can't see the document, at least can we be told, quite apart from the changing the cover and altering the policy references and really quite meaningless stuff, what really matters is to know whether it is intended that the SPP spatial framework will continue to be proposed to be refined by the use of maps 3 to 5 in the current SG or similar. That's the real substance that we need to examine at this inquiry. And it is extremely unsatisfactory that we should be approaching this position. Not with the Council's approval, that's another matter. You've got your committee cycle. But knowing from Mr Templeton what he actually proposes, that can be told to the inquiry, and it should be. And I make that request, sir. As to the RSS, well, that's out of left field. We'll have to deal with it when we see it.
Do you have a view on Mr Brown's suggestion of a supplementary recognition for Mr Templeton in lieu of the actual form of the proposed guidance being produced?
I'm never worried about form. I'm worried about substance. I really don't care how it emerges. Whatever document, whatever its heading is, as long as it's got the content, that's what I'm worried about. And I repeat, there is the risk of substantial prejudice to the applicants if we are not in a position to put this proposed content to our own witnesses. Either that, or it's going to get messy for obvious reasons after the event, after oral process is finished. And I really don't want that.
Mr Brown.
Sir, there is no secrecy in this process. The fact is that Mr Templeton and the officers responsible for this document have agreed how they wish to approach the committee to deal with the matter. It's completely inappropriate to expect an officer who may have thoughts on how the document should be changed to put those before a formal inquiry when they have not been approved by the party for whom he is acting. There's a democratic process here that has to be followed. For all we know, the committee members may have particular views about this matter, and it would be completely inappropriate for Mr Templeton to preempt the process which the document has to go through. Sir, it's unfortunate. I started by saying there is an unfortunate coincidence of timing, but the Council is doing its best to work with the issues within the framework of the inquiry, while at the same time respecting the process which Council documents have to go through for approval.
My difficulty is, Mr Brown, that normally if guidance was going to before a committee, you would have a form of the guidance that was to be put before the committee in papers to the committee. In this case, there's no form of the guidance being put in the papers to the committee. It's simply a delegated authority for variation of the guidance. In those circumstances, it seems to me not unreasonable to ask what's in Mr. Grant's head as regards what should be in the guidance, because the committee won't know either. I take your point about the committee, potentially the committee turning it down or the committee changing the resolution, but in normal circumstances, one would have a paper going before the committee with what would be in the guidance in it. So would it be possible, for instance, in a supplementary recognition or similar document for Mr. Templeton to set out precisely what the proposed changes would be that he would obtain, or that Mr. Grant would obtain delegated authority for?
Sir, I'm not in a position to answer that at the moment. I think there will need to be a discussion with those instructing me to find out exactly where we are. There is obviously no document which has been drafted or which Mr Templeton is happy with to the point where he could publish it along with the papers for the committee meeting, and I need to understand where he is in that process. What I would say, though, is again, the proposal for the committee is minor changes, and they will be obvious minor changes, as I've explained, such as updating the policy references to make sure there's a consistency when the documents are read across. But I'm happy to try to get instructions now, sir, if you would allow a brief adjournment for that purpose, or deal with it over one of the breaks, which may happen later this morning.
Well, perhaps we could deal with it once we've dealt with the conditions. Is that sufficient, Mr Trinnick?
We can deal with it, but I'm asking for a ruling on this point and not simply a let's see how it goes position. We're approaching the stage when evidence is going to be given. It's too late to shilly-shally, frankly. I think we need a proper ruling on this, and my request is a ruling that Mr Templeton should disclose what is in his mind about these so-called minor changes. I'm sorry to be cynical, but when I hear the word minor changes, it means nothing to me. I want to know what they are, so as to be able to put them to my witnesses.
Sir, just if I may, I note that Mr Chatterton is not to be available until approximately 11 o'clock, and I wonder whether it would be productive to get this issue bottomed out before then. I haven't contributed so far, and will do so if required or requested, sir, but certainly I would suggest that we really need an answer to this from Moray Council. So it may be to assist that if my learned friend is put in a position by his client's Moray Council to confirm professionally that the minor changes are indeed minor, of the nature of a new cover or altering references, etc., it may be that there is no issue, but one is wary that referencing to landscape capacity studies and the likes could not be covered by the word minor, firstly, and secondly, there could be an awful lot more to it, which we could be ambushed about.
Sir, if I may respond to that point. First of all, so far as Mr Trinnick is concerned, he used the term shilly-shally. I would hope it would be clear from the approach I've taken this morning that the Council is not attempting to shilly-shally here. I offer to take instructions at a break, and I will take those instructions at the break. During the course of our discussion, I have just received an email from Mr Templeton, who has reaffirmed that the intention is to make the minor changes outlined in the report to the committee. But, sir, I do think this is a matter where it would be better if I were to speak to those instructing me to get absolute clarity on the Council's position here.
I think I am content that Mr Brown should take instructions so that he can respond to this. I will make a ruling once I've heard those instructions, once I've heard what Mr Brown has to say on that. But I think it should be plain that my view is that we do need to know what will be in that guidance as things stand. Otherwise, I agree with Mr Trinnick. There's potential for substantial prejudice.
Yeah, thank you, sir. I'll proceed on that basis.
So I wonder if I can propose that, these instructions should be taken now. There is 30 minutes between now and Mr Chatterton giving evidence, and that would give every opportunity. Clearly, Mr Templeton's on the end of an email, so he can equally be on the end of a phone for my learned friend to take appropriate instructions. Then we know where we are about this matter.
Well, I was expecting that you would be that those instructing you would have heard what we had to say, and we'll be providing those instructions while we press on with other business. Is that possible, Mr Brown, or do you need to speak to them?
I think it would be better to speak to them,
right,
sir, in the circumstances.
Okay. In that case, we'll take a break until 11 o'clock and resume when Mr Chatterton arrives.
Thank you, sir.
Okay, so it's 11:10, so we'll resume now. Just before I go to Mr Brown, I just wanted to talk about how we're going to deal with the business today. We don't have Mr Chatterton left yet, so what I propose to do is once we've dealt with Mr Trinick and Mr Brown's point, we can move straight onto the business of dealing with conditions. And we can fit Mr Chatterton in as and when he arrives. What I would propose to do as regards the conditions, there are some conditions, in particular the noise conditions, where there are common interests between Gour and Rothes 3. So what I propose to do is take, in particular, the noise conditions altogether. We've arranged that Mr Shepherd should come, who's the noise expert for Rothes 3, should come on at about 12 o'clock. Assuming that's acceptable to Mr Steele. I know he wasn't involved in that particular discussion.
Sir, if that's what you've arranged, that will be absolutely acceptable,
right.
Yes.
So what I propose is at about 12 o'clock we go to discuss the noise conditions for both developments. So we discuss the Gour conditions other than noise conditions first. We then discuss the noise conditions for both developments, and then we discuss the Rothes 3 conditions. Is that acceptable?
That's fine, sir. Just to let you know, I'm only dealing with the noise conditions. Mr Nesbitt is going to deal with the remainder.
And, sir, from my point of view, I will not deal with conditions at all. Nicola Martin will deal with them. And on the question of Mr Chatterton, did I understand that you will interpose him as soon as he arrives? The reason I'm asking that is because we have got a couple of people sitting upstairs who are here only to listen to Mr Chatterton's evidence and make comments if appropriate. Then they will depart down the A9. So it would be very useful to know what's intended.
Yes, I think so. I think it's in the nature of discussion of conditions is that there should be reasonable breaks pretty often to change over, so that we can slot in Mr Chatterton.
We've actually just received confirmation that Mr Chatterton will be here at 12:30.
It's a very long drive from where he is, but there we are.
Yes. So, well, we've had some introduction to conditions, but for the condition session, but I think we should deal with Mr Trinick and Mr Brown's point first, and then I'll go around and make formal introductions for everyone who's going to take part in the condition session. Yep. Okay. So, Mr Brown.
Sir, may I start by recording my thanks for the additional time given to speak to my clients about this matter. We have been slightly hampered in our attempt because Mr Templeton is in a meeting at the moment, but we have managed to communicate with him electronically. The fact of the matter is there is no document which has yet been prepared But there should be comfort in the fact that the report, which is going before the committee, makes it clear that delegated authority is being sought for minor changes. There's no intention to make substantive changes to it, because obviously that would be beyond the scope of the delegated authority which is given. I suspect that the primary concern is the spatial framework considerations. Now, on that, it will be necessary to amend the maps appended to the guidance, but that will be to reflect the rural community boundaries, nothing more than that. There is map 1 and map 1 annexed.
So can you just hold on while I get hold of the maps here?
Certainly, sir.
Right. So, Appendix 1, yeah?
Yes, sir, it's map 1.
So you're looking at the wrong document. You need to look at the supplementary guidance itself. And map 1 is separately electronically available from the policies themselves.
Yes, that makes much more sense. I'm sorry. Yeah.
That would be CD 5.5, I believe.
Yes, madam.
Right, and map 1 is where? At the end?
So it's separately, I think, electronically separate from the
Right.
policies. Certainly when you go online, it is a separate document. It's numbered page 13 within the supplementary guidance, but I don't think you'll find it at page 13.
No, I do have in my electronic copy of mine, the maps are integrated, and I do have map 1, yeah. I'm sorry, Mr. Brown, if you'd like to continue.
Thank you, sir. And map 1 is the map which shows in pink the areas of greatest potential, and in cross-hatching in a darker shade of pink, potential development areas for extension and repowering. And the intention is to separate these maps out, but to be absolutely clear, there's no intention to change the boundaries. It's just to separate out the area of greatest potential and show that in one map, and show in another map the potential development areas for extension and repowering. And is it possible for Mr. Templeton to set out those intentions in a supplementary recognition? Yes, sir. That can be done, but and it will be done as quickly as possible. But obviously, I've not been able to speak to him about his commitments. I do know that I am due to see him tomorrow, so we can discuss the matter with him then. And of course, for the avoidance of any doubt, I think this is implied, but for the avoidance of any doubt, any thoughts will be Mr. Templeton's thoughts rather than the council's thoughts.
Yes, indeed. I mean, that's understood. Mr. Trinick.
I'm grateful to Mr. Brown for making his undoubted efforts to get proper instructions on this. I think I see where we're going, and that's extremely useful. It would be useful to have a supplementary recognition. If it's received by Friday, that's fine. We can deal with it by next week, but please not after Friday. And what I would want to see in that recognition, I'm not concerned about policy references and covers and what have you. What we're interested in is that map 1, and also to know if there are any changes to page 20 of the guidance, because at page 20, not 20, I'm sorry, it's 12, I think. Let's have a look. Yes, page 12 is where Murray Council explain how these maps are made up and what constraints are taken into account and how they're taken into account in terms of buffers and the like. So we need clarity on page 12 and following and on map 1. Also on page 20, I do refer to 20 now, the guidance on extensions and repowering of wind farms, to know if that text is going to change. So those are my specific requests in terms of information from Mr. Templeton in whatever document he produces. Thank you.
Sir, I wonder if I could seek an assurance as well. I have said very little, as you will have noted, because our interest is slightly different to Clash Gour. Our interest is in the landscape capacity study, and the document that has been lodged indicates that the Council accept that the landscape capacity study will be a material consideration for reasons set out in the report. However, I now seek an assurance that the hatched area within which my client's proposal is situated, save conceivably for a turbine or two, the hatched area is not to be in any way altered or amended in what is intended to be done by Mr. Templeton or Templeman or the committee on Tuesday.
So obviously, Mr. Templeton, yes, Mr. Templeton can only give an assurance as to what he's proposing, not what the committee will do. But I'll pass to Mr. Brown. Are you able to give those assurances? Are you able to? Is it possible to cover those matters that Mr. Trinick raised in the supplementary recognition? And is it possible to give, or at least to cover that matter that Mr. Steele raised in supplementary recognition too?
Yes, sir. If I may take those in order. So far as Mr. Trinick is concerned, I will certainly take the points away for discussion with Mr. Templeton. There's no issue with that, and we will deal with them as appropriate once I've had that discussion in his supplementary recognition. So far as Mr. Steele's point is concerned, I'm sorry if I wasn't clear enough the last time I spoke, but I thought I'd emphasised the fact that there is no intention to change the boundaries of any of the mapping so far as map 1 is concerned. The only change which will be made to that map will be to show the same information on 2 maps. Now, with regard to the timing of producing a supplementary recognition, there are 2 aspects to that. First of all, Mr. Templeton's availability to prepare that recognition, and secondly, we also need to have both maps, the map 1 separated out into 2 maps, and that obviously requires technical input. I'm told that Mr. Templeton is not available on Friday, and that the person who deals with preparing the maps is also not available on Friday. So, unfortunately, these matters will have to be dealt with on Monday, sir.
Is it really necessary to to provide the separate maps? Would it not be possible simply to give a description of what is proposed and provide the maps separately later?
Just to emphasise that, we don't need the separate maps. We just want to know what they intend to do. And we're not interested in rural groupings because there are no rural groupings relevant to at least Clashgower, I think Rothes 3. So we just want to know what the maps are going to do.
Oh, well, sir, on that basis, I've gone a step further than required then. So it's just a case of focusing on Mr Templeton's recognition. But it is likely that will be Monday. But in light of what I have said, there can be no surprises or should be no surprises in what he will say in the recognition.
Well, it would be very helpful if it could be before Monday, even if that... does it need to be particularly extensive given what we've discussed?
Well, sir, can I say this, that we will endeavour to have it ready for Friday, but if there's going to be any issue with that, we would email your office to let you know, and we will provide an explanation as to what the difficulty has been, but we will endeavour to have it for Friday, come what may.
And as regards the maps, if the maps could be, if it would be helpful to produce the maps, that would be, I don't see that they would necessarily have to be produced by Friday, but it might be helpful just to see an example of what's proposed.
Yes, sir. Well, going back to the air of suspicion which has run through our conversation this morning about what the Council is doing, my view was that it would be better to produce the maps so that it was clear what was intended. But we're meeting again next week, so we will certainly try to have them ready before the policy session starts.
Mr. Trinnick?
I'm grateful. Thank you. And thanks, Mr. Brown.
So can I just say that given the inconvenience that this matter is causing to the inquiry caused by Murray Council, I would have hoped, indeed expected, that everything that is in Mr Templeman's diary or anyone else connected with this matter would be immediately cancelled so that he could devote his entire attention to facilitating progress at this inquiry. This is an extremely expensive inquiry to run before Scottish Government reporters. It's been broadcast live, and I cannot understand why a supplementary recognition, which would only perhaps be a page or two long, cannot be produced by Friday. It seems utterly unreasonable to suggest otherwise.
Yes, sir. On that point, I have made it clear that every endeavour will be made to have it available for Friday. Well,
thank you, Mr. Brown. And I think we can move on to, having heard those points, we can move on to the conditions section. So, now, what we'll do is we'll discuss, as I said, discuss Clashgower's conditions without noise first. We have half an hour till 12 o'clock when we might expect Mr. Shepherd to come online. We can hopefully then discuss the noise conditions altogether. So, as regards the other Clashgower conditions, can I just check? It's Mr. Nesbitt, isn't it? Yes.
That's right, sir.
That's good. I think there may be some common issues, so maybe Ms. Martin will want to come in at various points too, simply as matters come up. And for the council, well, Mr. Caldwell is here for the noise session, but Mr. McPherson, yes, Mr. McPherson is here for the other conditions. And Mr. Brown, you'll be taking part too, will you? Yes.
Yes, sir. I will direct questions to Mr. Caldwell, Mr. McPherson, as I think appropriate.
Right, that's good. Right.
So can I just indicate that we had hoped and intended to have one or two others coming down to join in the condition session to keep the numbers down. I'm going to retire upstairs,
okay.
But one or two are coming down. So if I can just indicate them.
Could you just say whether it is one or two, so that we know have the right number of microphones for them?
I'll double check, sir. Is it two coming down? Is it two? Just one. Sorry, just one, I'm told.
Just one. It may be wise to bring them down now,
Yes.
just because there are matters of common interest between the two proposed developments.
And I will retire, sir, to keep numbers to a minimum.
So just to, for those who are watching who don't know about how conditions are dealt with in these kind of circumstances, there's discussion of conditions under which consent might be granted, and that's without prejudice to any decision, any recommendation we might make, or any decision that ministers might make. So the council is not conceding anything by discussing conditions under which consent might be granted. It's not conceding on its position at all.
Sir, may I just add, the gentleman to my left here is Andrew Smith, Project Manager from Force 9 Energy. Hopefully he'll be able to assist in the conditions session as well.
All right. Mr. Smith, do you have a microphone? Yes.
I do, thanks.
Good, right. Right. So what I propose is that we simply take the printed copy of the Glashgar conditions and we run through from start to finish, as I say, leaving out the noise conditions. So on condition 1, that's agreed between the council. These are the conditions of the Section 36 consent. So we'll come on to the conditions of the deemed planning permission subsequently. So on condition 1, I'm sorry, Miss Martin, I've started off, and you're waiting for someone to come down from upstairs still.
Yes, sir, but if you're focusing on Glashgar just at the moment.
Yes, okay. So I'll just keep going, and if you tell me if you need someone else to speak on a particular matter, then we'll just keep going.
Thank you, sir.
All right. So on condition 1, there was one minor point I was going to raise. There's a definition of the condition relies on definition of final commissioning, which is at the end of the document. The condition, the definition of final commissioning relies upon the term first commissioning, which isn't itself defined. So I hope everyone will trust me to add in a definition of first commissioning, which would be equivalent to the definition of first commissioning in the Rothes conditions, which I can tell you what it is. Yeah, final commissioning is defined it's page 24. It's the earlier of the date on which electricity is exported to the grid on a commercial basis from the last of the wind turbines forming part of the development erected in accordance with this consent, or the date falling 18 months from the date of the first commissioning, which is not itself defined. And the definition of first commissioning in the Rothes conditions is the date on which electricity is first exported to the grid on a commercial basis from any of the wind turbines forming part of the development.
So, very content with that. That's an omission on our part, so I'm happy with that.
Right.
Just before we move on, sir, Mr. Trinick had something to say about the description of development, which was a...
Oh, yes, of course.
I'm
I'm sure we should have
we
covered
can either
that.
pick that up now or later on in the process.
Let's pick that up now.
I'm grateful, sir. It's unusual, perhaps, for an applicant to propose a description of development for Section 36 and deemed planning permission purposes. It's there for a reason. Dealing first with the Section 36 description, we must remember that section, it's solely to regulate access to the grid and you applied in order to overcome a prohibition in section 36(1). That's why it's there. The 1990 rules, application rules, do not specify any content of the application, unlike the development management regulations. And the notice of application to be published under section 36 simply says you do a map and a name of locality and place. It's pretty vague stuff under section 36. So all that really is required in the description is that which has been set out as a proposal by the Gour applicant. You may say, why are you worried about it? The answer is this, that there has been, you will be aware of the Finney case, section 42, and the difficulties that can arise if certain detail is put into a description of development which prevents you using section 42 of the 1997 Act to vary planning conditions. The recent letter, I haven't got the CD number, but it's the 27 August letter from the Chief Planner, which starts about the consenting regime, but then goes on to make it clear that Section 42 is a perfectly respectable jurisdiction to manage conditions on the Deemed Planning Commission, and there is a proposal to introduce a direction to notify Scottish ministers of Section 42 applications. So it's very much a live and useful jurisdiction, but it can be displaced if the description of the development specifies matters which could be the subject of a Section 42 application, meaning that the developer then would have to go through a Section 36C application to vary the entire consent, which may be regarded as somewhat heavyweight to achieve what may be a minor conditions adjustment. So that's the reason for the wording we proposed. So far as the Deemed Planning Commission is concerned, sorry, the 27 August letter of CD 1432 is concerned, Regulation 9 of the 2013 Development Management Regulations obviously specifies what you need to do in terms of description of development and the address of the site and the necessary plans to identify the locality and the site. We believe that what we've put in the description of the development is perfectly adequate. That does the job so far as although the development management regulations are not directly applicable here, it's in the spirit of those regulations. And again, the reason for putting this forward is the Section 42 reason, that we do not want to have tip heights and the like specified within the description of the development, because that would fall foul of Finney when it came to a Section 42 application. We want to preserve the ability to use Section 42. That is why that proposal has been made. So, any questions you have on that?
And you've covered, was it in condition 13? Well, the two options for condition 13. You've covered the turbine heights and locations as well by reference to a plan.
Yep.
Are the turbine locations covered in the description? No. No. Okay. Right. Well, I hear what you say, and I'm sure you'll make written submissions on that too.
I will.
Yeah. I'm not a legal advisor to the Scottish ministers, so no doubt they will take their own legal advice on that arrangement.
I understand that, sir, totally. But we're trying to wean the ECU off its default approach, which is giving rise to the issues we're trying to overcome with this wording.
Right. Of course, I mean, if I suppose just thinking it through, if there were a Section 42 application, it would be an application for the whole development, subject to that variation, and therefore it would most likely fall under the requirement for environmental impact assessment in any case. Perhaps you don't need to comment on that.
I think so. That would be called an ecomedical question. There are two answers to that, and yes. I know that Mr. Nesbitt and I disagree. So
you don't want to incriminate yourself.
I think I'd rather not incriminate myself on that one.
Mm-hmm. Right. Well, as I say, I hear what you're saying, and no doubt the Scottish ministers will take their own advice on that approach. Yeah.
Sir, would you like to hear? Sir, would you like to hear from Rothes 3 the approach that's been taken to the description?
Now, I did have a particular question on the approach taken by Rothes 3. Yes, I think it would probably be sensible to hear from you, but I do. Perhaps if I ask my question first, you can cover that while we're dealing with it. Now, in both the original proposed development and moving on to the Rothes 3 conditions, or the Rothes 3 description of the development. I think I've just give me a moment. Oh, right, yes, no. That's Graham asking if you could bring the mic a little bit closer to you, Ms. Martin. Thanks. That's great. In the description of the development, there's a change from what was proposed in the application. In the original proposed development, there's removal of turbine 15 and associated infrastructure. And in the alternative proposed development, there's an amended description. Now, I wonder, there's only one application made for one particular description of the development, which is as described in the first part of the description for the original proposed development. Sorry, I'm a bit too close to the mic, I think, in turn. I wonder if any change really ought to be made by condition rather than just by a change in the description of the development, because essentially the Scottish ministers would be approving the application subject to certain changes, which I think would normally be done by condition.
Sir, yes. First of all, is that better? Can you hear me? Can you hear me?
Perhaps just a wee bit closer still.
Right. Is that better?
Yes, that's lovely. Yes.
Thank you, sir. Yes. The table of conditions for the alternative proposed development at condition 7 to the deemed planning permission does provide for the description of the reduced layout scheme. And I accept that in the description of development, that should, instead of reading 23 turbines, it should in fact read 29 turbines. Right. Otherwise that description would be the same, would be the application description, except that the application description in the original proposed development now also refers to the removal of turbine 15. Now, that could be addressed just by condition if you felt that was appropriate, and that inclusion in the description could be removed if you thought that was appropriate.
So if I just drafted a condition similar to condition, the one you've just referred me to, condition 7 of the Rothes conditions. So
in both tables of conditions, condition 7 has been drafted for the OPD to remove turbine 15.
Yes. And
then for the APD, just to remove the 6 turbines that are described.
Of course, yes. That's quite right. Yeah, yeah. Okay. Right. Now that makes sense.
Okay, thank you.
Okay. Right. So back to the Gour conditions. We've dealt with condition 1. Condition 2 relates to the commencement of development. It's interesting to have 2 sets of conditions to compare. The equivalent condition in the Rothes permission requires written confirmation of the intended date of commencement to be provided to the Planning Authority and the Scottish Ministers no later than 1 calendar month before that date. The reason I raise these inconsistencies between the two conditions is I will no doubt be asked about them if I have inconsistent conditions in some substantial matter. So, or if we have them rather. So I take it that would be an acceptable change to the Glashgar conditions.
Yes, sir.
Right. Okay. Non-assignation, I don't think there's any concern there. Serious incident reporting, I do, again, comparing the conditions between the two developments, the Glashgar's condition only requires a report of the incident within 48 hours. Rothes' conditions require a report of the incident within 24 hours. I don't know what this reflects about the two developments, but is 24 hours acceptable?
I've no difficulty with that at all, sir.
Sorry, I didn't catch your answer.
I've no difficulty with that.
Right, okay. Aviation radar, I don't think there's any question there. The next condition is radar. I don't think there's any question there. The next condition is also radar, and I don't think there's any question there. Condition 8.
Sir, just noticed on the run through this morning, condition 7 is in fact on the section 36 consent.
Yes.
And there was a reference, it actually came to us from the airport and we used it verbatim because that's what they insisted on.
Yeah.
But it has a reference to local planning authority and there should be Scottish ministers, it being a section 36 condition. So
that should... Sorry, sorry, I didn't catch that. So should it be a reference to the Scottish ministers, or would you prefer it to be a deemed planning?
No, I mean, traditionally aviation conditions tend to be on the section 36 consent. So I think if we could amend in the 1, 2, 3, 4th line down to local planning authority, if we could amend that to Scottish ministers, that would attend to that.
Okay, all right. Thanks for that. Condition 8, I don't think there's any difficulty there. Condition 9, this is about the final decommissioning. One thing I note here, and possibly quite a big thing, is that there is a provision in the Rothes conditions for a decommissioning bond. I don't see, and maybe I've missed it, but I don't see equivalent decommission or other financial arrangement, but I don't see an equivalent provision here for a decommissioning bond or guarantee or anything of that sort.
So in our discussions, that never been requested or mentioned, but
right.
If it's something that you think you require, then certainly we'll consider it. Right.
Perhaps I should. I'm sorry. My plosives are coming out a bit loud. Is that something that the council has no concern about? The decommissioning bond for Glashgar?
Sir, I'll allow Mr McPherson to answer that question.
It's generally perceived that it would be safer to have one in place, but it's not something that came up.
I'm sorry, I'm not catching you.
Sorry, if we had a choice, I suppose that would be safer to have one in place and be consistent with the other application.
Right. Okay. Well, I think my position is I would like to be consistent between the two. I'll let you take instructions on that, Mr. Nesbitt, if you want to, and we can maybe come back to it at the end.
Yes, please, sir. I'm sure we can come up with some wording. It's been done before, so okay. Give me a few moments and I'll come back to you on it.
We do have an example in the Rothes 3 conditions. So
the thought had occurred to me, yeah.
Okay. Supply of electricity to the national grid. I don't think there's any problem, any issue I've got to raise there. Please, just to emphasise, please stop me as I'm going through if anyone wants to raise anything. Condition 11, I don't have anything to raise there. Condition 12, I don't think I've got anything to raise there. Condition 13, now this is a slightly odd form for us. I think what's actually intended here is that these are two options actually for ministers rather than two options for the company, which is the developer, to choose from. Am I correct there, Mr. Nesbitt?
Not quite, sir.
Right.
So the proposal is that we are able to choose either option. Mm-hmm. And you'll see towards the end of the condition, point C, on page 5, there's a requirement there to notify the council in advance which option my client selected to implement.
But presumably one of the... Oh, sorry, carry on.
Just to finish that connects then to condition 36, and it effectively triggers aviation lighting. So, I mean, arguably the greater includes the lesser, but we thought it better to set out both options as have been described very separately in the proposals, and there's a difference in terms of lighting.
But it may be, of course, that ministers decide only to authorise option B, in which case, well, I think we as reporters would need to, in our recommendations, to put forward a full set of conditions for either option. But we would make our recommendation that if ministers chose to authorise only, to consent only option B, then they simply delete the first part of this condition. Otherwise, I guess it makes sense that the company could choose one or the other.
Just so, sir. The text is there. It would take some relatively modest amendment to the condition to achieve a selective version.
And as you say, the same issue comes up at condition 36, doesn't it? Yeah.
That's correct.
And 37, 36 and 37, yeah. Okay. Right. Condition 14, I don't have any issue there. Condition 15, agreed by everyone again, don't have any issue. Condition 16, don't have any issue. Condition 17, don't have any issue. Condition 18, I've scrawled in the margin, should there be a reference to the EIAR Technical Appendix 3.1, which is I think it's the outline or draft construction method statement. Well, I think it's... Is it worth having such a reference, Mr. Nesbitt, do you think, or...
I'd be content with a reference. I mean, ultimately, the material is there to be seen. It's going to be approved by the council. So, yeah. To the extent we need to call on that document, it's there to guide the proposal. But I'm in your hands with that. Right. Relaxed.
Okay. Condition. So that was condition 18. Condition 19. I think there may be a minor omission just running through the schedule of mitigation. It doesn't seem, the condition refers to Technical Appendix 3.2, which itself deals with certain pre-construction surveys, but it doesn't deal with all of the pre-construction surveys required. They're set out in the schedule of mitigation in the EIA report, schedule mitigation. So it doesn't expressly cover otter, bats, badger, water vole, I think, which are in page 17.5 of the which are in page 75 of the schedule mitigation. I assume you'd be happy for those to be added if necessary. I'm sorry, I'm not sure if I was completely clear there.
No, you were, sir.
Right.
I think they may be covered at
Right.
condition 29.
Okay.
If we just have a...
Oh, yes. Yes. Otter, badger, water vole. Yes, of course they are. Right. Now, condition 20, we've got...
Sorry, sir. Sorry, Murray Council. I'm just thinking of having drafting conditions myself. For condition 19, you're obviously referring there to SNH. It's just for this and other conditions, if SNH is changing title, I'm thinking about if there's any...
I'm sorry, I'm not catching you.
Sorry, if there's any, just looking at condition 19 and other conditions, if any organisations have changed title, like SNH, Nature Scotland, I'm just seeing that in the conditions throughout.
Yes. Well, it's an interesting question. I think they've changed they've kind of changed their public persona, but I don't think they're SNH trading as Nature Scotland, I think, rather than changing anything in law. So I don't think
I just mention that because sometimes for some conditions it's something that gets flagged up.
Right.
You're consulting somebody that may or may not exist anymore. But
right. Okay. We'll look into that and
okay.
check it. Yeah. Okay. Now, on traffic, there's two conditions here, 20 and 21. Well, actually, there's more than two. Is there? No. Well, there's two conditions. There seems to be quite a lot. One is the council's draft, and the other is the applicant's draft, I think, and they're both agreed. But there seems to be quite a lot of duplication between the two. Is it necessary to have all of this? Who should I look at first?
So I'll just comment quickly. This was in the scheme of all this, a reasonably contentious condition to negotiate. The council was pretty firm about keeping its wording. I think it was actually intended to be both. I'll check that in a moment. But we reviewed the terms of the condition. There was nothing in there as a matter of substance that gave us any cause for concern. Right. And it was an easier position for us to just accept what was being put to us by the council. But perhaps I can let the council comment on that.
Well, just before the council do, obviously, both the council and the applicant can have views on conditions. And conditions might be acceptable to the applicant, but might set perhaps an undesirable precedent as far as ministers are concerned. So we just need to be a bit cautious, I think.
I completely understand what you're saying. In our preference would have been a slightly simpler condition. I think the council's roads team were concerned to ensure that everything was addressed in this condition. On the matter of substance, and in order to get the conditions agreed, we have no difficulty with it. But our starting point would be a simpler condition, if that helps.
Okay. Mr. McPherson.
That's a fair summary of our transportation section's position. Ultimately, we tend to find that the access arrangements and delivery for wind farms tends to be the thing that causes the most trouble. So our transportation colleagues with the odd black eye and bloody nose tend to try and make the conditions as prescriptive and as clear as possible. And certainly, having discussed the draft conditions from Glasgow with them, they were fairly adamant that they wanted the condition as prescriptive as they have given. I suppose in terms of the test of conditions about precision, it does no harm to be that precise. But if there's any overlap in there that you've spotted, then we're happy for that to be removed. But we're keen to have the conditions worded as prescribed.
Well, I'll just run through what my concerns were. Just a sec. Well, first, actually, in condition 21, prior to the commencement of any part of the development, the following must be submitted. What does any part of the development mean?
I think that, from experience there, that's been caught up where there have been maybe, and this is me just trying to recollect where this has come from, where you have, say, for example, an existing forestry track that will be utilised to deliver things to a site. There's different accesses, making sure that we have information in advance of what others might determine to be, well, that's pre-works, or that's enabling works. Maybe we fall back to the description of the development that's elsewhere in the decision notice. But I think we're just trying to be comprehensive, making sure that any works related to the development that effectively trigger the provision of the information that the condition requires. Right.
Okay. Yeah. Okay. I see that. So it's not several stages you're looking at. It's simply any part of the development that comes first. It requires that all of this needs to be dealt with. Yeah.
I think that the example I gave was another development. They were talking about enabling works that were, and now they're straying into the debate about, the description of the development. Just making sure that anything that's meaningfully part of this development that starts to occur triggers the compliance with the condition.
Okay. In condition. In Part A of the condition, that seems to be covered by condition 20A and B. I acknowledge that there's more written there, but the suspensive nature of condition A means that there's a number of points that are rather like this. Matters could be taken as simply as guidance. That the matters raised by the council can be taken as guidance as to what they might be expecting under condition 20A and B.
This goes back to discussions that we've had in previous developments where you'd think that would be the case, but you end up in an argument about what information should be submitted, and that's why our transportation colleagues are keen to make sure that the conditions are clear as possible about what they anticipate comes in.
But ultimately, if it's the council that's approving matters, it makes it very difficult for the developer to proceed without the council's approval, and in a way the specification can be dealt with at that time, can it not?
I think it's just a question of precision. If we know exactly what we want, it's useful and helpful to have that condition prescribed just now. And ultimately we've been in situations where there's arguments about fairly fundamental stuff. Like ultimately one of the areas of contention elsewhere in this public inquiry has been the absence of fundamental information about delivery of turbines. Fairly basic stuff that was mentioned at scoping, which was ignored. So we're keen to have our conditions as precise as possible to, albeit after the fact, prevent that kind of discussion having to take place. Right. If you can volunteer exactly what we want now, then it helps everybody, and it helps the public know what we're anticipating to be told to us at that stage.
Okay. Well, there are very similar issues about B and C that I think it's the same kind of issue. I hear what you're saying about precision, so we can take that away and have a further look at it. At D, I'm always a bit nervous about wear and tear agreements, not least because it seems to be a duplication of Section 96 of the Roads Scotland Act, in that section specifies in statute what the Roads Authority can expect to be provided by an operator of certain types of transport. I'm a bit nervous about conditions duplicating that.
We were slightly mindful of that ourselves, and we've rather tactfully or otherwise put in the reference to evidence that. I think it's just we want to be sure that that's provided timeously and correctly. I take your point. I think we just wanted to make sure that that was in the focus of the developer. But we refer to it as evidence that the wear and tear agreement is in place. But it's covered under other legislation We acknowledge that, but we just don't want that to have lost sight of that and what's expected of the developer.
Right. Okay.
So for our part, we made the point that that was duplication, but as it's going to be done anyway, in all likelihood, we took a fairly relaxed approach. But I understand from your perspective, I think it is duplication of another statutory provision.
Okay. Well, there are various points, but I think they're all fairly similar. There's a question as to how much specification and how much specification is required in a condition. So I think we can take those away and look at them. I don't think we need to look at them just now and take up inquiry time with that. Right. I think we can move on to condition 22. Again, this is the road bond. Again, I see this as agreed. Again, this is something that makes me a bit nervous about the precedent that it might set if Scottish ministers start requiring road bonds. Do you have? I think one way to deal with it, and I don't expect you to necessarily come up with an answer right now, but if you can point me to a precedent in conditions of other wind farms where the Scottish ministers have agreed a road bond, that would make me a lot more comfortable with that kind of condition. Sorry, am I being clear? Yeah. Okay.
I'm trying to recall.
You don't need to just now, okay, Mr. McPherson, unless it comes straight to mind. If you just let me know in due course, I'll make a note of that. Hours of construction and delivery, that all seems fine. Micrositing, yes. So we're going over page 10 to page 11. Just above the reason and the paragraph above that again, any proposed micrositing that does not meet these criteria, which are that no wind farm or other infrastructure may be microsited to less than 50 metres from watercourses. In the case of turbine 47, it may not be microsited closer to an existing wind turbine, and the general provision that there may be micrositing within 50 metres. Any proposed micrositing that does not meet these criteria, so I understand that to be the criteria that micrositing may be within 50 metres, may be permitted with the prior written approval of the planning authority. Am I right in understanding that, or is it? So which criteria are we talking about? Does that allow the development to go outside the 50 metres, or are we just talking about setting aside the two bullet-pointed criteria just above?
So my take on that condition is beyond 50 metres. Beyond 50 metres, if right. Approved in specific approved, right. Circumstances. Okay. So it may be in those circumstances the council might wish to be assured of certain matters of detail. Right. And it would be, I think it's too much to try to specify that in the condition. But it's certainly possible that micrositing might occur beyond that. If there were no additional effects arising from that. So we would like to try to retain that flexibility.
Yeah. Just, Ms. McPherson, what, do you have a view?
Yes, a similar approach was taken, I understand, at Dornell, where within I think it was 25 metres or 50 metres, there was a degree of comfort to the applicant that they didn't have to go through any process. But beyond that distance, they had to get written approval, and we both went through an exercise of checking water courses and other matters that might be a trap to that. But that was certainly my interpretation of it as well, was that beyond 50 metres, a slightly more iterative process would be undergone to check that was okay, right, within reason.
The reason I'm bringing it up and the reason I feel a bit uncomfortable is that obviously the proposed development has been subject to environmental impact assessment with specifically the limitation that micrositing would be within 50 metres. Outside the 50 metres, it hasn't been environmentally impact assessed. That's not a verb, is it? Assessed. Well, it hasn't been subject to environmental impact assessment. So I wonder, I imagine there's still scope for non-material variation of the permission. So perhaps we could just simply add in that, so long as this was non-material variation, would that work?
That's certainly an option. Another option would be, and I've seen this done elsewhere, to add the words, provided that there are no, this gives rise to no additional significant environmental effect. Just to cut that off, if that was a concern. But either approach.
Wouldn't such an approach require a planning application if it was more than non-material variation?
Not if permitted by the terms of the condition.
Okay. I suppose the concern then is, don't you have to carry out an assessment to identify what a significant effect is? Is it possible to limit something in that kind of way?
I would say it's similar to a screening exercise, sir.
Right.
That if there's sufficient information available to make it obvious that no effects are going to arise, then it's similar to a screening judgment, effectively, as almost like a subsequent consent.
Maybe no likely significant effect might.
Yes, yeah, that would be a better term.
Okay, well, I think we'll probably need to have a think about that, but that sounds like a solution.
It's commonplace now for many non-material variations or even permitted development inquiries to undertake an assessment. So it's quite common for amendments to applications or variations or non-material variations to have to go through that process anyway.
Okay, well, right. We'll have a further think about that. As I say, I'm not the Scottish Minister's legal advisor, so it may be that they would want to have a look at that. Okay, so over the page is 27. I've got scrolled down here, monitoring question mark. I think there was a commitment in the schedule of mitigation to monitoring of various ecological matters. I'm afraid I haven't scribbled down any more than that. I do have a reference to the schedule of mitigation, which is 17.4. So, Mr. Nesbitt, should there be a requirement for monitoring added in there, or is the requirement? Have I missed the requirement of monitoring? It's elsewhere in the conditions.
I can't answer that immediately. If you might allow us to.
Do you want to come back on that? Yeah.
If that's all right.
Okay, sure.
Thank you.
It's just the reference I've got noted down. I mean, I'm sorry, my note is not very extensive. It just says monitoring question mark, EIAR schedule of mitigation, page 17.4, if that's helpful. Okay. Condition 26. I've got 2 points noted down here, which the first is and appointment for decommissioning. This is about the ECOW, the Environmental and Ecological Clerk of Works, his or her appointment and role. And I don't think there's a requirement for, maybe it's covered in other conditions, but I don't think there's a requirement for appointment for decommissioning for the ECOW. Perhaps you can either let me know now or later whether it's appropriate for the ECOW to be, for a requirement for the ECOW to be appointed for decommissioning as well within that condition. This is just my comparison with the Rothes 3 conditions again.
Yeah, I think if you looked at condition 9, it's in our version. There's a reference to it in condition 9 in terms of the appointment of
yes,
an environmental ecological clerk.
Yeah.
It's just a slightly different approach.
Yeah, sorry, I missed that. Yeah, thank you. I wondered also, neither Rothes 3 nor, in fact, the role of the ecological clerk of works is slightly different in the two permissions. But one thing that struck me was that there's no requirement for the ECOW to monitor compliance with environmental protection legislation more broadly. Is that something that does normally the ECOW's role, or is covered in a condition beyond the very specific points that the ECOW is required to cover?
I think our view is that it's a targeted role rather than a broader role on the development. There's
Okay.
perhaps other people managing the project that would have responsibility there, and it might start to cut across how these projects are normally managed.
Right. I'll maybe have a look back through other conditions. I suspect other conditions are similar to this. So,
Yes. Yeah.
it was just a question that occurred to me. Okay. We've just got a few more conditions to go. I see Mr. Chatterton sitting patient at the end. Perhaps if we can mark the place that we're at. We're on condition 28, and we can take Mr. Chatterton's evidence now if everyone's content to do that. I don't want to keep him waiting.
So there's also a question of Mr. Shepherd. What time is he going to be here?
Right. Oh,
he also has a schedule as well as Mr. Chatterton.
We have a message from Mr. Shepherd and is following the procedures on the webcast and is ready to dial in when we get to that stage for the noise conditions. So he's quite happy to listen in the meantime.
Right. Okay, that's good. Okay, so Ms. Chatterton, would you like to come up? And if you sit here at that witness table, you'll have a microphone.
So if he sits there, I can't see a thing. The screen is between us.
Well, I'll move the screen to one side.
Yep, fine.
Okay. Good. I'm sorry that we couldn't make the technology work this morning. So thank you for coming in to give your evidence. So what I'd be grateful if you could do is read through the recognition that you provided, the witness statement. I'd asked if you leave out the parts that are to be dealt with in written submissions. So that was the matter relating to fire safety, and also leave out the part that we said wasn't to be pursued, which was the option for low severity fires as an option for managing peatland, which is in the kind of the last two sentences in paragraph 10. Okay, but otherwise, if you just read the whole thing.
I would just say apologies in advance. My hearing's not very good at the moment at all. This here just supports my glasses. This one is bunged up. So it's a double apologies for the difficulty in hearing, and also I might do a very good Brian Blessed impression in terms of blowing out microphones. So apologies to everybody.
But if at the moment you just move the microphone just a wee bit closer to you, I think everyone could hear a bit better then. That's it? Yeah.
That's right.
Okay.
Okay. So in terms of the precognition that I've got, should I just read through that as is? I've deleted out the peat reference, and I'll just read the amended one as was. Is that okay?
Yes. Yes. And then there may be some questions for you.
All right. Can I also say right at the outset, despite the technological hiccup, I really do appreciate the Clash Gour guys for actually sending the stuff through. A lot of time and effort went into that. Yeah. I'm just sorry it didn't work out on the actual morning. Okay. I am Andrew Chatterton, and I reside at Tap Farm, situated close to and between the two proposed developments and the existing wind farms of Rothes 1 and 2, Berryburn and Paul's Hill, and the Berryburn 2 wind farm application that's now been registered as of Friday the 14th of August. I hold a BA Honours in Business, although I previously studied geology at undergraduate level. I hold a Deer Management Qualification 1984 from the British Deer Society, Deer Stalking Certificates 1 and 2. I am an approved witness for the DSC scheme, and I instruct DSC qualification courses. I am a self-employed outdoor instructor, following a lifelong interest in regards to various aspects of the outdoors, including deer management, wildlife, shooting, and bushcraft, etc. I contract to the holder of the Deer Management Service, covering much of the forest known as the Dallas Forestry Complex, which includes much of the ground covered by the Clash Gour proposal. I am a trained volunteer for the Scottish Fire and Rescue Service Community Asset Register, providing 4x4 and ATV support to the emergency services. In furtherance of this, I have completed a course via the Open University in Wildland Fire Ecology. I've previously submitted an original letter of objection in respect of Clash Gour and Rothes 3, emailed to the reporters dated the 5th of May 2020, which dealt with ornithology and various matters, a response dated the 4th of June and an addendum dated the 16th of August to MacArthur Green reply of the 26th of May to the elements of the above email. And apologies because I note that I should have had permission to actually do that reply, so I apologise for that oversight. And the inquiry report. I wish to let those earlier submissions stand as part of my evidence and will try to avoid covering those points in detail again. I do refer to my email of the 5th of May 2020 to the reporters detailing various issues, but particularly in my struggle to gain online access data. Those issues remain in place at the date of writing. Consequently, I have not had the opportunity to thoroughly review all the available data, evidence and submissions, and my comments here necessarily reflect that reality. From online data, Moray occupies, and this is data that I've acquired rather than it was provided, Moray occupies about 0.1% of the UK land area. built, permissioned and applied for wind development will see 11% of the UK onshore turbines. From TAP, I can look southwest and see the Glashgower Wind Monitor Tower. Force 9 tell me it is 90.5 metres tall. This is very close to where it is proposed to site a 180-metre turbine, either T31 or T32. Considerably more bulk than the thin tower with rotating blades. Tip height will be approximately double that of the existing tower. Not one of the many visualisations with which I have been provided by Force 9 shows anything like the actual scale of that turbine is going to be. I am forced to question the reliability of all the visualisations. Traffic impacts on the surrounding roads and specifically along the access track and through TAP have not been addressed, though I did spot that there was a comment had missed that it would be addressed as part of the inquiry. Commercial forestry intensity has increased in advance of the development at Glashgower. This has created immediate impacts relating to traffic, access, water, fire and wildlife per my detail in the inquiry report and previous submissions. Acknowledging that the developers are not currently on site, the inquiry still has to conclude. They're not in charge specifically, but once they are in charge, the continuity of the contractors will remain, and I can only base my concerns on what's going to happen on what I've already seen. It seems accepted that the standard for sound specified for a suburban environment will be used to gauge the impact in a rural setting. Little I can argue will sway that stance, and I remain of the belief that it is not a good measure. That there will be alien noise impact at TAP on a regular, if not continuous basis, that conditioning and other measures will provide weak protection and impractical routes of remedy. This is reinforced from the direct observation of similar matters, and particularly the recent inquiries at Paul's Hill 2. Industrialisation is not conducive to reduced disturbance. Wildlife will adapt and differing species will come forward, but it is not the original ecosystem. It will be a post-industrial one. Published science can be located to support more or less any particular position. I quoted one, low severity fires enhance long-term carbon retention of peatlands, dated 10th of May 2020, Flanagan, Wang, Winton and Richardson, simply because it was recently produced in the Scottish Gamekeepers Association magazine and seen an illustration. It seems relevant on several fronts, not least the carbon question. Much of Glashgower is afforested, so peatland areas are damaged already, but construction will impact open peat areas and further disturb others and the available management options. 11. Renewable energy has a crucial role to play. There is a place for it, and I support that. I do kind of see the irony of being sat here in that I live off-grid. I don't wish to boast, but I had the first wind turbine on that hill. I've used wind turbines. I have solar power. My issue is one of saturation. Outside wider considerations of structure, cost and security, I feel the balance is skewed. Whilst only partially relevant given the exact Glashgower ground, peatlands represent an ecology rarer than rainforest. Quite simply, if these applications were for construction in a rainforest area, the matter would have been rejected out of hand, I feel. The issues covered are aimed at the developments in question, but largely constitute generally applicable points. There are locations far more suited to such developments. Fundamentally, Moray is already carrying more than a fair share of capacity, and enough is enough. I therefore request that the Minister rejects both applications, including the various en route amendments that have been made.
If you just stay there for a moment, Mr. Chatterton, these gentlemen, this is Mr. Trinick here, who is the representative of the Glashgower applicant, and down there is Mr. Gordon Steele, who is the representative of the Rothes 3 applicant. They may have questions for you. I'll take Mr. Trinick first.
Thanks, Sue. Good afternoon, Mr. Chatterton.
How do you do?
Can you hear me okay?
Just about. You now have an excuse to shout at me with a free rein.
I wouldn't dream of it. Just a couple of questions, if I may. The Clashgar applicant, sharing cost with the Rothes 3 applicant, I think installed an aerial and enhanced broadband at your house and loaned you a tablet. Is that right?
Sorry, say again.
The Clashgar applicant, sharing cost with the Rothes 3 applicant, installed an aerial of some type, provided enhanced broadband, and loaned you a tablet. That's correct, isn't it?
That's apologies to Rothes 3. I didn't realise it was shared cost.
Oh yes, yeah.
The only what was provided was a high gain antenna that was actually usable for my vehicle, because there was no signal at the house. We had to drive out to get a reliable signal.
And it was tested by Clashgar applicant or its representative on installation and worked, even if it didn't work this morning. Is that correct?
Yes, that's correct.
Right. But you're here now, so are you happy that you've had the opportunity to present the evidence you wanted to present?
Yes, I am.
You're content with that?
Yes.
Thank you. Now, do you know a Willie Jackson?
Yes, I do.
Yes. He's on the Scotland Against Spin Facebook site, isn't he?
That's correct.
And you're a member of Scotland Against Spin?
I am, yes.
And
I follow it, so yes.
Have been since the 23rd of December 2018, I see.
Right.
Yes. And the Scotland Against Spin, it campaigns against the Scottish Government's wind farm policies, doesn't it?
Yes, probably. I haven't looked at it at the global. I've looked at it in respect of this issue. So they probably are against the Scottish Government's policy per se.
Okay. Thank you very much, Mr. Chatterton. Those are my questions.
Mr. Steele.
No questions. Thank you, Mr. Chatterton.
Thank you. And again, apologies to Rothes 3 about the not saying thank you to them for the provision of the aerial.
My colleague, Mrs. Black, doesn't have any questions. I do have a couple of questions. Obviously, we went to visit your property, for which we're very grateful. I think it was a couple of days ago now, is it? Yes. Now, there's a block of apparently...
I took advantage of coming here.
Yes, thank you. In the wind, we managed to lose one of the wire lines, yes. There's a block of apparently mature pine trees to the sort of west or southwest of your house.
Yes.
Is that on your land or is it just beyond it?
It isn't. My boundary is just this side of those trees.
Right. So they're just outside, yeah?
Yeah.
They belong to the landowner there?
That's it. That falls under Coldwell's.
Mm-hmm.
There's no felling application at the moment, but from the age and position of the trees and the discussion with Coldwell's, my understanding is that block will probably come down within the next 5 to 7 years.
Mm-hmm. Okay. How often do you go west of the site? Sorry, not west of the site. West. Do you ever travel into the forest westward of your house?
I do quite often. There's various elements to it. I take part and I also manage some of the deer management that takes place on a wide area there. There is also the Ryebrek property further into the forest, which I hold the key for and I look after on behalf of the owners. So that will get a regular visit. Plus, I have dogs, so we'll probably head that way to go walking. So I'm probably down that track 4 or 5 times a week, if not more.
Okay. Now, you'd referred to the anemometer, the wind monitoring tower in your evidence. Can you see that from inside your house, or is it only from your garden?
Hear the monitoring tower.
No, see it.
See it. No, only you see it from the front doorstep and sort of as you turn right out of the house, because it's partially shielded by the trees, pardon me, until you actually step away from the front door. There are no windows facing that direction.
Mm-hmm. And you'd also mentioned in your evidence hearing Rothes 1 and 2 when there's an easterly wind. Mm-hmm. How often is that?
It tends to be mostly in the winter. I would say, obviously in terms of a witness on noise issues, I'm not particularly well equipped, but probably 2 or 3 times a year. And it's not a particularly loud noise, but it is detectable against the background, and we don't hear that in the house.
Okay, thank you very much. That's very helpful. Thank you. Well, obviously there's no re-examination, so I think that concludes the evidence today. So thank you very much for coming in, Mr. Chatterton.
Right. Thank you very much. Thank you very much for your time, and thank you everybody for your patience. Sorry for the technical issues this morning.
Well, these things happen, I think, and obviously we're very grateful for everyone's efforts.
Okay. Thank you very much.
Thank you. Now, Mr. Trinick reminded me, and it was very remiss of me not to notice the time passing. We also have Mr. Shepherd waiting to give evidence, and I'm just going to look over at Graham and see, would we need a break before Mr. Shepherd giving evidence? 5 minutes, Graham's saying. So I think just to avoid holding up Mr. Shepherd, perhaps we could take his evidence next. We could deal with noise conditions generally next for the 2 proposed developments.
So when you say his evidence, so far as Gour are concerned, I think we're just talking about a discussion on conditions, aren't we?
Yes, I misspoke, Mr. Trinick. It was simply the discussion on conditions. If we held the discussion on conditions on noise conditions for both Rothes 3 and Gour, I recognise there's different issues, but also similar issues. Mm-hmm. So if we take a break for 5 minutes just so we can establish the connection with Mr. Shepherd, and so we'll come back at about, well, let's say 45, sort of 1:15.
Sir, just as we have our break, would it be possible to have the screen moved again, because now the council team has lost sight of you?
Oh, yes, of course. Yes,
Thank you.
I'm sorry. Yes, you do definitely want to see me, yes.
Yes, it's helpful.
We don't have... we've got Mr. Trinick now, good. And Mr. Brown and Mr. Gregor back. Good. So, just to set out the scope of this discussion, we have what I'm looking at, I think, and I'll be corrected if I'm wrong, is in the Rothes conditions, we have condition 22 and 23, and in the and I think also in the Rothes conditions, the conditions in respect of borough pits are not agreed. Is that correct? Yes. Okay. And in the Gour conditions, we have condition 42 is not agreed and condition 44 is not agreed. Is that correct, Mr. Trinick?
Correct.
Right. Okay. So, sorry, I should have asked people, asked who all is contributing to this. So I think we've got Mr. Shepherd. Hello. Can you hear me?
Good afternoon. I can hear you. Can you hear me?
I can hear you very clearly. Yes, that's great. And we have Mr. Caldwell for the council. Yep, good. And Mr. Trinick as well for Glashgar. Or Mr. Trinick for Glashgar rather. And Ms. Martin, you're taking part in this too, aren't you?
Yes, sir.
Yes, good. Okay. I think is that everyone? Well, maybe Mr. Brown will contribute to. Yeah. Good.
I'm me, sir.
All right. So perhaps we can start off with the noise, the main noise condition, setting limits. In both cases, there are certain limits set. And as I understand the position, and I may not be understanding it correctly, the council wished to include provisions in respect of amplitude modulation in that main condition. The Rothes 3 applicant have a slightly different arrangement on amplitude modulation, and the Glashgar has a slightly different arrangement again. Now, perhaps I can just go around everyone and get them to explain their own position rather than me explaining everyone's own position. But it would be helpful. One of the things I was looking back at was places where this had been dealt with previously in previous Scottish planning decisions of ministers or decisions of reporters on appeals, and there's not a great deal there. So it would be helpful if people could direct me to any decisions of ministers or appeal decisions that they think are relevant to these particular conditions. So who shall I start with? Well, I'll start with Mr. Trinick because we've been taking Glashgar first, and then I'll come to Mr. Shepherd, and then I'll go to Mr. Caldwell. Yep. Okay.
So thank you very much. Looking at the Glashgar conditions, yes, it's 42, but I think we need to note the points at which AM becomes relevant. It becomes relevant at the start of condition 42, where the council have inserted a reference to amplitude modulation penalty, which we don't have, for reasons I'll come to. If you then go on 2 pages to the start of the guidance notes, again, the council's version refers in the paragraph just above guidance note 1 to the amplitude modulation penalty. And then if we go over a couple, 3 pages, we have guidance note 6, which with a graph, which is the penalty rating provision proposed by the council. So the council proposed to quantify the penalty in the condition, and then they say at each integer wind speed, total penalty determined in accordance with Guidance Note 3, and the amplitude modulation penalties determined in accordance with Guidance Note 5 will be added arithmetically, except where the AM penalty and the tonal penalty relate to the same characteristic, e.g. amplitude modulated tones, only the larger of the AM or tonal penalty should be applied. So it's not double counting, and that's very straightforward. And then there's Guidance Note 5, which simply says we're in accordance with the assessment protocol agreed under the noise condition, etc., etc. So it's not entirely specified as to how this penalty will be applied. We say we would rather have condition 52, which you will see on the page after Guidance Note 6, which requires the submission of a scheme of investigation of potential excess amplitude modulation for the approval of the council. Why do we take this position? I need to backtrack a bit, but I'll do it very briefly. That if we go back to 2013, IUK, Renewable UK, proposed a method of quantifying AM. The Good Practice Guide, well, neither ETSU document nor the Good Practice Guide deal with AM at all, so we find no help there, except on, I think it's page 65 or 66 of ETSU, where it notes blade swish, but that's very much a starting point of no use now. The IOA proposed in 2016 a method of quantifying wind farm AM occurring in any given 10-minute period, with results being expressed as a single decibel value, equivalent to the average peak to trough, maximum to minimum variation in noise, for 3 separate frequency bands, with the overall AM level to be taken as that for the worst case over those three frequency bands. So that's what was proposed. But there was no recommendation as to how the individual 10-minute values should be used to regulate AM in a planning condition. Now, the quantification process recommended has, I think, been widely accepted. Moving forward, the UKG, what we now call BAYS, it was DEC, commissioned some research, produced a couple of reports, which commended the IOA's quantification method and proposed the same penalty as the IOA come up with. But neither of the reports provided a methodology by which the penalty scheme could be applied in practice. And forgive me for delving into why, the problem to which that gives rise, and which leads to our suggestion for condition 52. AM is likely to occur under very specific conditions. It doesn't occur all the time. So it's not appropriate to simply add the penalty to each 10-minute noise level. You need some degree of averaging across the 10-minute periods so that you actually provide meaningful operational noise levels. Otherwise, you're going to get penalised based on a single spike in a single 10-minute period, which I don't think is the objective, and it wouldn't be fair. You can see already, so from what I've rehearsed, this is not a straightforward topic. And where we are now is that very little progress has been made since 2013, 2016, because this is an issue which largely occurs in England, not in Scotland. And there's been no wind energy development in England for a long, long time, for reasons we know. So nothing's been happening, nothing's been developed. So we are really where we were in 2013 or the IOA report in 2016. Which means much of the methodology about the implementation of the penalty has never really been properly tested. And I think there are also question marks, I understand, I'm not the expert, about the way the AM penalty is aggregated from the minor time interval of 10 seconds to the major time interval of 10 minutes, and then further aggregated in the way I described, so you don't get penalised for a single 10-minute period. And a lot more testing is required before we can say, yep, we've got the method, we know how to apply the penalty. That is why we suggest that there should be a scheme condition, because whether or not development revives in England, there may be some further progress. We may know better in a few years' time how to apply that penalty, how to approach the question of should the penalty apply in a particular case. Our case is we don't really know that at the moment. We fully acknowledge that AM needs to be addressed by condition. That's not the argument. But we don't want a fully quantified and guidance note 5 provided for condition at this stage. We're happy to agree a scheme. I'm sorry to take time, sir, but it was important that you understood why we are proposing what we're proposing. Thank you, sir.
And the scheme set out in condition 52 would be made at the time of a written request by the planning authority following a complaint,
yes,
rather than being a suspensive requirement before the proposed development was commenced. Yeah,
that's how it's phrased. Yes, sir. I see the point of your question, but that's how it's phrased. Right.
Okay. Mr. Shepherd, do you want to set out the position for Rothes 3?
So the position is essentially the same at Rothes 3 as it is at Gour, in that Moray Council have proposed this penalty-based scheme, or a penalty-based condition for AM, whereas we've proposed a scheme-based condition. And I think Mr. Trinick's very clearly summarised the history of AM and where we are at the moment. But my preference for a scheme-based condition is twofold, and one is that it allows latest research into AM to be taken into account when developing the scheme at the time of any AM complaint. And there is a lot of ongoing work in terms of amplitude modulation, in the way that, firstly, the level of amplitude modulation in each 10-minute period is quantified, and then secondly, how that is then applied as an average or as a metric that's then relevant for either a penalty or to give you a rating level of the level of AM to allow that to be investigated. So because research is ongoing in that respect, a scheme allows any protocol to be developed at the time of a complaint that can take into account the latest research. So, for example, at the moment, this international standard on wind turbine sound power level measurements, IEC 61400 Part 11, the committee group associated with that standard is currently developing protocols for measurements of wind farm noise at receptor locations, which will include amplitude modulation and how that should be investigated and the results determined. And so research like that can then be taken into account with the scheme. And then my second point in terms of having a scheme-based penalty rather than, a scheme-based condition rather than a penalty-based condition is that amplitude modulation, where it may be complained about and an issue at a residence near to a wind farm site, the level of AM is not necessarily at its worst under downwind conditions, which is when the level of broadband noise tends to be its worst. So there then becomes a difficulty in applying the penalty for amplitude modulation to the overall level to determine a rating level, because it's much better to investigate where AM is occurring and try to define the wind speed, wind direction and atmospheric conditions that prevail during the AM, during any AM complaint, and then target any remedial action or mitigation to those specific periods. And just purely having a penalty doesn't necessarily allow for an investigation to the complaint to necessarily address the complaint as well as a scheme could, which could then target any mitigation, like I say, to the specific conditions under which it arises.
So you're saying essentially amplitude modulation is specific to particular circumstances which may or may not be where the receptor is downwind of the turbine, that there may be various different circumstances.
Exactly that. So in terms of broadband noise, if a complaint is made about noise from the wind farm, then you essentially know that you narrow down your wind direction range to being when that property is downwind of the wind farm, and then you know for that subset of wind direction the measured levels occur to to the worst case or the highest levels of noise from the wind farm. Whereas with amplitude modulation, that may not be under the same conditions. The level of amplitude modulation varies for different wind directions and wind speeds in the same way that overall noise varies with wind speed and wind direction, albeit that they're slightly differently. The worst case level each may occur at different wind speed and wind direction conditions.
Yeah, so I'll ask a daft question, which I should perhaps have addressed to Mr. Trinick first too. What causes amplitude modulation? Do we know?
So again, this is an area of ongoing research. We've the speculation, which is generally the consensus now is it occurs under high wind shear conditions. So when the difference between the wind speed at the bottom of the rotor sweep to the top of the rotor sweep is high, and also when the pitch angle of the blades is such that the inflow of the air is on the limit of the turbine going into stall. So it's a particular function of those two elements. So you have to have for high levels of wind, for high levels of amplitude modulation to occur, you typically have to have that combination of a high level of wind speed, so high difference of wind speed over the plane of the rotor blade, and also that specific turbine needs to be operating in a way whereby it's on the edge of going into stall. So when there is this high shear across the blade, then the turbine does then go into stall at the top of its sweep, and that's when you get the higher level of modulation.
So if it helps, I mean, I can't match Rob Shepherd's technical knowledge, of course, but it's been explained to me in lay terms, that second part of the second factor, as sailing a boat, when you do close to the wind and the sail starts flapping. In other words, you stop getting energy gain, but the loss of energy gain as you get closer to the wind can produce other effects, and that may be a factor.
And just a question to you both before I come to Mr. Caldwell. How predictable is amplitude modulation?
So in terms of wind farm sites, it's something that can be difficult to predict when it's going to occur. So there are no specific models that allow one to predict when it's going to happen, albeit that it is a rare phenomenon because it does depend on those two elements that I explained earlier. But if it is an issue, and if there are complaints about amplitude modulation and measurements are made using the IOA metric and correlating the derived amplitude modulation rating level with wind speed and wind direction, allows one to then quite clearly determine for wind speed, wind direction and time of day what the specific conditions are whereby it arises, and therefore sort of narrow down where mitigation needs to be implemented.
So would it be fair to say that with any given wind farm before it's erected, you wouldn't necessarily be able to predict whether amplitude modulation would occur, but once it's erected you would have more idea, it would become a more sort of predictable phenomenon after that, if it occurred?
If it occurred once measurements are undertaken, then yes, if there is amplitude modulation, it would occur under those conditions that you've been able to measure and define.
So that's why we don't really want a suspensive condition. I think these, for reasons Mr. Shepherd says, you need to know how things work around the site in the relevant terms before you can start putting together a scheme.
Okay, well, I'm sorry, I put a number of questions to Mr. Trinick and Mr. Shepherd. Perhaps we can take it in two parts. Is there anything, first as regards the technical matters that they've discussed, is there anything that you disagree with there, Mr. Caldwell?
I'd say credit to Mr. Trinick for a good timeline of where amplitude modulation has been. It remains a complex issue. I agree with Mr. Shepherd. When it may occur is not known. You can't predict it. Yes, research is still ongoing. In relation to the IOA metric, which came out in August 2016, that's had all-round support as a good metric to quantify amplitude modulation. And Council, we took that forward as an example planning condition from Institute of Acoustics Technical Bulletin, which came out in November, December 2017, which was a broad consensus of specialists on this subject. And that's the condition that we brought forward where, yes, it's correct to say that we are suggesting a penalty should AM occur, in addition to should there be any tones that would affect your overall rating level. The distinction with Glashgower and Rothes 3 is they would rather either be a reactive scheme in response to a complaint for Glashgower and in respect of Rothes 3, that it be a scheme-based approach. At this point in time, we're providing at least a methodology, a prescribed process to deal with it. I don't know what scheme is proposed in the future. The planning condition, as is, does have reference to any future update to the IOA metric method. So it does have regard to further changes as this whole subject evolves. But that's a broad overview from what's provided by both Mr. Trinick and Mr. Shepherd. We've also used it in relation to complaint investigation, the IOA metric, and it's been found to be quite a good way to find out where it's occurring and if it's significant or not.
So can you just take me through how the Council's condition would work as regards amplitude modulation, just so I understand?
You'd be, directed to Guidance Note 5 and 5B references the IOA 2016 document. And prescribed within that document is the method of investigating the presence of AM. And you'd follow that through, and where incidences were found of AM when greater than that 3 dB peak to trough, then a penalty would apply to the overall rating level, which is on the next page, page 22.
That's in the diagram, yeah?
Yeah. So incidents of less than 3 peak to trough, there'd be no penalty applied. So that would also take you back to the rating level on condition 22. No, sorry, I beg your pardon, wrong wind farm. So, just as an illustration, if you were on page 18, we have a table of limits. And for ease of purpose, we'll use the left-hand column, where you've got Tom Cork from 4 to 12 metres per second. So if you follow through your IOA methodology and found it, say, 7 metres per second, you'd measured 40.6, but there was a presence of AM, and then you would add 3 to your rating level to be at 43.6, which would be in breach of condition.
But so the concern. Sorry, I'm just being a bit slow. The concern about that particular. This is the same arrangement that the council is proposing for both proposed developments, isn't it?
Yes, sir. It's the same arrangement through the conditions rather than anything as a suspensive or reactive scheme.
And the concern that Clashgar and Rothes 3 have about that is about the specific methodology of measurement of AM.
The problem can be seen highlighted in Guidance Note 5, because where in accordance with the assessment protocol agreed under the noise condition, so stop there, and that noise protocol you'll find obviously in under condition 42 itself. There is only one protocol, and that's specified in 42B, which is more or less the same terms in our condition and in the council's. So you appoint a consultant who develops procedures, gets them approved, and then makes measurements. Coming back to Guidance Note 5, it says, where in accordance with that protocol, noise emissions at the location, etc., contain, and I emphasise, or are likely to contain an amplitude modulation component, then the penalty will be applied, indeed has just been described. Our issue is in those words contain or likely to contain, because although there's the metric which Mr. Shepherd has described, there is the problem that we both described, which is how you go about it in site-specific circumstances, knowing that it contains or is likely to contain. And I'm not sure that condition takes you to that point. In fact, I don't think it does. You would need much more than that. And that's why we've recommended the scheme approach rather than the Guidance Note 5 approach. All you have in the Council's version, and I respect their position, let me say, that it's a difficult topic. All you have are the words contain or likely to contain. It doesn't tell you how you get there.
Okay. Well, perhaps, Mr. Caldwell, first, could you respond to that? And second, can you tell me what your difficulty is with the scheme condition?
Well, I'd be reading down into Guidance Note 5B where the analysis for AM is prescribed in the IOA metric, so the method of doing it is contained in there. I think what I alluded to earlier was in relation to a scheme-based approach. It's maybe just a lack of certainty as to what's actually proposed. It may well be in time nothing changes and what's proposed is what we have here, but we don't have that understanding as to what kind of scheme is envisaged at this stage.
So just going back to Mr. Trinick and Mr. Shepherd, just in terms of the metric, what I understood from what you were saying was that the difficulty is in establishing whether that there isn't that the methodology is not defined for establishing when a penalty should be applied in the method for rating amplitude modulation in the IOA document. Am I understanding that right?
Mr. Shepherd will speak to this much better than I can.
Right, okay.
That's my understanding. That the guidance note 5B tells you how much.
How much, yes.
It doesn't tell you how you get there. But Mr. Shepherd will tell you far better than me.
Right.
That's exactly it. So the IOA working group document determines the amplitude modulation rating level in each 10-minute period. So it's a method for rating the level of AM for each 10-minute period. It doesn't go as far as telling you what to do with each 10-minute period to average it, and then it doesn't go as far as saying how that average should be used to determine a penalty. So in terms of the ongoing research into amplitude modulation, the penalty level is something that would be within that, because we don't know, as it is at the moment, whether the rating penalty level as specified within the planning conditions does fully represent people's perception of the sound at their property. It's the reasonable point to be at the moment based on the current knowledge, but with further research that penalty level may change, and in addition there isn't any research into how tonal noise and amplitude modulation combined together is perceived by a receptor. And so the Moray Council proposal of adding the amplitude modulation penalty on to the tonal penalty, except where you've got modulated tones, there isn't a level of research associated with that addition of penalties to allow the certainty that is appropriate necessarily.
Sorry, I'm being very dim. I thought amplitude modulation was a kind of tonal noise. Am I wrong there?
No. So amplitude modulation is associated with the swish of the blade. So it's when you're hearing a wind farm, you generally hear just a broadband swish type noise from the wind farm, and then the extra swish is the amplitude modulation. And so where that swish of a broadband sort of overall level goes up and down, that's your amplitude modulation. But typically it's not associated with tonal noise. They're two distinct and separate things.
Okay. I think I'm understanding where we are now. Mr. Caldwell, I think do you want to respond to that point about the there not being a method laid out for identifying when the penalty should be applied in the method for rating amplitude modulation?
The condition as we've promoted did come through acoustics bulletin, which really purported to, as we've written it in. We also took advice, independent noise consultant, who gave us those conditions in respect of AM and the guidance notes for it was Rothes 3. We have, for consistency's sake, promoted the same for Gour. We've also put that forward for Paul's Hill 2, which we're still awaiting a guidance on. So we feel our position has been understood by our consultant, who thought the position was reasonable and provided that to us.
Right. I think I understand where all the parties are on this. We'll obviously have to take this away and make our report to ministers. Is there anything else anyone wants to say on this topic?
No, I think so. You've heard what you need to hear, and I think Mr. Cornwall's been very fair in his approach.
Can I just add one last, a more general comment in relation to that topic? Obviously, in the event that we do get a complaint at some point in the future, one thing we're always mindful of the conditions is how long will that complaint endure until it's either addressed or can be dismissed. And obviously, with the suggested condition by the applicants, the time that they might, upon a request from us, pull together some scheme in the future to address this matter and then it be implemented, would more likely see a longer duration of possible effect on any complainant than the approach that the council seeks.
I'm sorry, I didn't quite follow that. Could you just explain again?
In more simple terms, when you have a suspensive condition that's seeking to deal with and address something that's the subject of a complaint, it will take longer to deal with than a condition that tries to address it up front.
Can I just make a quick comment on that point?
Of course, I was going to come to you, yeah.
Thank you. Just on that specific point, in terms of any complaint from a resident that the Moray Council upholders requiring an investigation, in terms of any sort of noise from the wind farm, a protocol is required by the conditions to be developed and submitted and agreed with Moray Council. So the scheme-based condition isn't any different to any the broadband condition, which still requires that.
One last question on this topic before we leave it. Well, it's kind of a question in two parts. I'd asked if anyone could refer me to any case where a similar condition, either a scheme condition or a reference to amplitude modulation in the standard noise condition, had been included in a decision by the Scottish ministers. I haven't heard anyone direct me to any case such as that so far. Mr. McPherson, sorry.
I'm maybe being a bit naughty. I know that the other side are very, very good at demanding sight of things in draft. Our understanding is that the reporter for Paul's Hill 2 has put his report to ministers. So that should be somewhere for sharing.
I'm not sure if I'm allowed to look at that. I will ask. I never have before, but I'll ask to know if I'm allowed to do that.
For why?
I don't think it's subject to freedom of information, I'm afraid. Not even for, it's particularly not for civil servants.
Can I make reference to there are
yes, of course,
not in Scotland, but in the IOA document, Malden District Council in respect of Turncoal Wind Farm, make reference to an AM scheme, and Denbrook condition as well. But to date, I'm not aware of Scottish ministers approving an AM condition. Colleagues in Aberdeenshire regularly put that condition at non-Scottish minister type wind farm development, as far as I'm aware.
Sorry, I'd said my question was in two parts. The other part of the question was there's a statutory scheme for addressing nuisance. Noise as a nuisance. Given the position that amplitude modulation is relatively unpredictable at any given wind farm, is it not appropriate just simply to rely on statutory nuisance?
Answering in reverse order, I'd really rather you didn't. I'd like experts to look at a noise complaint, not the court, with absolutely no knowledge of noise at all. That's dangerous. Equally, I think it's appropriate in planning terms that an issue which needs to be addressed by condition, should be addressed by condition, rather than leaving it to another jurisdiction. Answering your first point, I'm not aware of any Scottish examples of conditions, but we will research that and get back to you, because I haven't looked at it, to be honest. Rather, you didn't refer to Denbrook at all, something obviously rather well known to me, but they did impose a quantified condition at Denbrook, and it's caused nothing but trouble and a visit to the Court of Appeal since.
Okay. Oh, Mr. Caldwell.
Yeah. Can I comment on, in terms of statutory nuisance regime? I don't think occurrence of AM in terms of duration intensity is going to support something that's beyond is intolerable, as would be described in nuisance. So I don't think that's going to be a remedy that any council will follow in relation to AM. I'd find that highly unlikely. So I think I agree with Mr Trinick. The planning system should be the way to try and deal with it in terms of amenity.
Good. Well, I think we understand where everyone is on that. So I think we can move on to the other noise conditions. Now, I think the first one to deal with is the other condition that was controversial for Clashgar and that's also controversial for Rothes 3, and that is condition. Hold on.
44.
It's 44. That's right. 44. 44. That's right. For Clashgar, and the equivalent condition for Rothes is 23, I think, is it? Yes.
That's right, sir.
Yes, that's right. Good. All right. So I understand what's at issue here is a requirement to the council are seeking a requirement that there's noise measurement after the turbines are erected. To identify compliance with the standard condition with the emission levels set out there, and that's repeated every 2 years. And perhaps the best place to that's correct, isn't there? There's a reasonable summary of the condition there. Perhaps I should ask you to deal with it, Mr. Caldwell. Start off with just to explain it rather than me trying to explain your position.
Yes, sir. Our condition as proposed is that a noise survey be carried out within the first year of construction, and as the conditions laid out, subsequent tests are carried out every 2 years, or that frequency can be reduced or in fact got rid of altogether, which is clearly based on a pattern of evidence of good compliance with noise limits. So, in a practical terms, you maybe measure within year 1, come back a further 2 years, measure, and then there's an opportunity to say we're well clear of non-compliance issues, we don't have any history of complaints. Then we would look again at seeking a reduction in the frequency of testing, maybe 5 years, or maybe even at that stage be content that it doesn't need to continue. So, I appreciate the contention will be the amount of potential shutdown and the frequency and costs of tests that could be envisaged. I don't see that in practice being, if you want to calculate them out, 12 tests over 24, 25 years. I don't envisage that actually being the case, but I think we need a bedding-in period to see how the noise, as Mr Trinick said in relation to AM, how the local situation is actually settling in. The limits we're providing for both schemes are, when you take the thing cumulatively, are still quite significant levels of noise, and so we feel it's reasonable. They are large-scale developments covering large areas, and we don't feel it's unreasonable to have a proactive look at noise levels, with the caveat within the condition is framed that that can be reduced where the predicted levels don't come out the same as operational levels. If operational levels are deemed much lower, then that frequency of testing. And that's something that we've applied in practice in our area, and I know in neighbouring Aberdeenshire frequently we regularly look at reductions in frequency of tests where it's okay.
So have you applied this? What the question I was going to ask was, have you applied this arrangement to other developments, maybe not just wind farms, but other forms of development elsewhere in Murray?
It's predominantly a wind farm condition. We have applied that where we've had a test in year one and a further test within 2 years where we're comfortable with the situation with the wind farm and there's no complaints.
But not to other forms of development, just to wind farms, or?
I think just to wind farms, as far as I can recall. Yeah. Sometimes we may have a condition that requires a developer to test some industrial process, but I think there's more variability in wind farms.
Variability?
Sorry, in terms of wind speed, if you have a machine that makes a certain noise, then say a planning application for some factory, and at that stage perhaps the ventilation system or whatever isn't actually known or prescribed, you may put in a condition that says build it and within a set period of time carry out a test to confirm that your predicted levels your operational levels meet your predicted levels. So there's no interaction between atmospheric conditions or wind speed or any other factors or large distances. It should be quite straightforward to say at that point that the plant they put in was going to be is now fine. Another point in relation to testing is that obviously in this, I think it's Gour, you have 4 or 5 different potential turbines that were modelled as candidate turbines, so it's just confirming that variability when you do further testing.
But if it was a factory, would you return every 2 years?
No, because there aren't variabilities in terms of atmospheric conditions and wind speed variabilities and so on. So it would be done as a one-off.
Right. Okay. So who should I go to first? I'll take Mr. Trinick first, and then Mr. Shepherd.
Okay. So my position is very straightforward. What we're looking at here is basically a complaint-driven system. That's the starting point. But we accept that it's entirely reasonable to initially test the acoustic performance of the turbines against the rating conditions to make sure we can comply. But beyond that initial test, we say it's both unnecessary and unreasonable to ask for more testing, especially if there have been no complaints. If the wind farm is living happily with its neighbours, why go on testing? There's also the cost factor. It's not inconsiderable because even on the initial test, you are looking, as the condition says, at a range of wind speeds from 4 meters a second up to 4 to 12 meters a second, and a range of wind directions. And to capture those may take some time, especially easterly winds or whatever. You don't know when it's going to happen. This is quite expensive. And that factor does come into account. The condition as proposed by both parties, by the Gour applicant, does say that the requirements under the condition will cease, in fact will only cease, once the planning authority confirms that the rating condition is met. So there is a point at which you say we can meet the rating condition. The council has said in email traffic that yes, but what about wear and tear over the years? The commercial answer to that is you don't allow wear and tear because that implies energy loss, energy capture loss. It's extremely important to keep those turbines up to scratch to make sure you're maximising energy capture, especially in terms of the condition of the blades. So we say it's unreasonable and unnecessary. The council have also referred to interaction with other developments as a reason. I don't know what that means. I think you'll need to ask them, and I can respond if necessary. Thank you.
Well, in that case, I'm sorry, Mr. Shepherd. Can I just go to Mr. Caldwell first, just to explain that particular point, and then I'll come back to you.
That's not really my form of words, interaction with other developments. I think I agree that's not helpful. What we have to consider is this wind farm and its noise levels related to these wind farms. And when you're assessing the wind farms, you're assessing the contribution that wind farm makes. What other wind farms do, I think I have to accept that's not really relevant to this argument. And they are covered by other conditions which we need to deal with.
Okay, Mr. Shepherd, yes.
Thank you. In respect to Rothes 3, our maximum predicted noise level in the for the original proposed development was 32 dB and 31 dB for the alternative proposed development, and the noise limits proposed or the agreed noise limits, the maximum noise limit is 34 dB for the original proposed development and 33 dB for the alternative proposed development, and these noise limit levels are very low. They're lower than the lowest noise limit within ETSO R97, which is 35 dB. And therefore, in this case, we've shown through the EIA and the AI that the noise limits proposed and agreed within the conditions are easily achievable, and therefore it may not be necessary to carry out the post-compliance noise measurements. So in addition to that, I think I can understand that it may be reasonable and necessary to request post-construction compliance measurements as a matter of course where the predicted noise levels are close to the ETSO R97 upper daytime noise limit of 40 dB or the night limit of 43 dB, or where predicted noise levels are plus 5 dB, or that limit is set at plus 5 dB above background, which would be higher still. And specifically where mitigation is shown to be required to meet these higher noise limits. But for Rothes 3, that's not the case. Our predicted noise levels and our noise limits are very low, and therefore for that reason I don't think that the post-construction compliance measurements are necessarily required, and certainly the ongoing compliance measurements every 2 years wouldn't be necessary if the initial compliance measurements were very necessary to show that the limits would be met, because there'd be no reason to see noise levels from the wind farm change with time. And then two additional points that arise out of that is that there is the complaints-driven limit, so the complaints-driven condition within the noise conditions. So if a complaint is received and Moray Council believe that that's a valid complaint, then the operator is required to carry out compliance measurements. So that covers any changes with time or indeed any initial noise complaints that are received that are determined to be valid. And then in addition, we have come across this condition before in Aberdeenshire, where repeat measurements are required every 2 years. And in those circumstances, we've agreed after the first or second round of monitoring that where we've shown that the noise limits are met, then there's no need for ongoing measurements, and that's been agreed. And I think that in itself may suggest that the 2-yearly measurements aren't necessary, because where they've been proposed in the past or applied in the past, that two-yearly limit has been relaxed. And then my final point in terms of the Rothes 3 proposal is that predicted noise levels from the Rothes 3 turbines are very low, as I say, maximum of 32 dB. And it's likely that those noise levels are very close to, or indeed below, existing background noise, or existing noise including the existing operational wind farms. And where you're trying to measure very low levels of noise from an operational wind farm, it can be very difficult to exactly determine what the noise level is from that wind farm, and requires extensive shutdowns of the wind farm to determine whether or not there's a significant background contribution to then enable you to calculate the wind farm noise level.
But on that last point, that would arise if there's a complaint, and you have to look into the complaint, wouldn't it?
You would. So if there's a complaint and operational noise levels are low, very close to or below background or other noise, then, as I say, it can be very difficult to prove conclusively what the noise level is from the wind farm. But there is usually a provision that allows you to carry out measurements at a point between the residential property and the wind farm to determine the noise levels closer, where you've got a better signal to noise ratio, and then you can extrapolate from that closer measurement to determine whether or not the limit would be met at the residential property, and that would be something that would be agreed within the protocol, or agreed with the council as the measurements progress, if that's necessary.
Because of course, just sorry, I'm being dim again. If you're responding to a complaint, you'd only be measuring noise in respect of one property, whereas if you're verifying the position, you'd be doing all the noise measurements again, wouldn't you? Is that right?
So we've specified, if you were minded to accept the Moray Council condition requiring post-construction compliance measurements, those measurements would be limited to 3 properties. And so we would suggest that the council would select those 3 properties, and it would likely be the 3 nearest properties, or 3 properties in different directions from the wind farm to determine whether the limits are met at those locations. But you're correct, in terms of a complaint, the measurements would be at that one specific location.
Right. Well, I think I'm understanding where the parties are on this too. Mr. Caldwell, do you want to come back on anything that's been said there?
No, I think that's a good summary of that. There is a slight distinction maybe between Clash Gour noise limits. They relate to a background noise survey, so the noise levels are slightly higher than at Rothes 3. In terms of the limits that we're setting at Clash Gour, that's really about as much as we would seem as reasonable for a daytime situation, and that is because it's a very large scale development, and I think it's why we want to see a bit more monitoring than just what's been proposed, because it is basically at the maximum kind of level for Clash Gour alone, but in combination with the existing other wind farm development. But other than that, yeah, I would agree with Mr. Shepherd's points he makes.
And sorry, just to go back to Mr. Shepherd, just to confirm, Rothes 3 is opposing even the condition that's been put forward by that's incorporated at the moment in condition 44 of the Clash-Gour condition. So there wouldn't be Rothes 3 doesn't think there should be any any requirement for a post construction compliance. They should simply go to the regime where there's a response to complaints in respect of noise. Am I understanding that correctly?
That's correct, yes. In this circumstance, because the predicted noise levels are low and the limits are low, then we don't think that immediate post-construction compliance measurements are necessary.
Right, good. So I think I understand where everyone is.
So just to finish off, unlike Rothes, so we're not at the highest levels at all allowed by ETSU, but we are at a higher level, and that the margins are not as great as at Rothes, so we do accept fully that it's sense to have an initial compliance test. That's not in dispute. But I maintain the points about subsequent testing once you've shown compliance with the rating limits. Thank you.
Well, I'll look briefly to Mr. Caldwell to see if there's anything more on that.
No, I think that's a good all-round exploration of it, I think, from our
Good.
point of view. Thank you.
Thank you. So I think that deals with the two issues that were controversial for Clash-Gour. Am I correct on that, Mr. Trinick?
That's right, sir. Thank you very much.
Yeah. So what I will do now, I think we still have a number of conditions that are controversial for Rothes 3 relating to borough pits. Am I correct on that?
So they're not strictly related to noise, so they are matters that we could cover when we go through the other. Could go through the other conditions contained in the tables.
Right. Okay. You don't think we need Mr. Shepherd then here for those particular conditions? We can rely on the paper that he's provided. Is that?
Yes, we can rely on the paper provided and the discussion we can have.
Right. Okay.
This
Good.
afternoon.
Well, I see I've kept you long after lunchtime, and I'm very sorry for that. And we do still have some conditions to deal with, which I was. So I suggest that we say thank you to Mr. Shepherd and Mr. Caldwell, and we come back to deal with the remaining conditions, the remainder of the Clash-Gour conditions, and the remainder and also the Rothes conditions that we haven't discussed after lunch. And should we just take 45 minutes for lunch?
Even less if you want.
Well, if our lunch is ready, we can maybe take half an hour. So it's 1:50 now. If we come back at 2:20, and thank you very much, Mr. Shepherd. We'll conclude this part with you and Mr. Caldwell. I don't think we need to detain you either. So thank you very much.
Thank you.
Thank you, sir.
We're good to go. Right. So we were looking at the Clash-Gour conditions, and we just looked at condition 28. So moving on to condition 29, that deals with wildlife surveys. I don't think that's an agreed condition. I don't think I've got anything to raise there. Forestry 30, I don't have anything there. 31, I don't have anything there. 32, I don't have anything there. Oh no, hold on. 32. Oh yeah, no, I just noted that presumably the compensatory planting would be part of the wind farm project for EIA purposes, but any significant effects wouldn't be known at this stage, but that's a point that can be dealt with when the condition, when the application is made for approval under the condition. 33, nothing there. 34, nothing there. 35, there are the two options again. We talked about that. 36, ditto. 37, air safety, that's a condition that comes from elsewhere. Yeah, from the Ministry of Defence, isn't it? 38, I didn't have any concerns there. 39, none. 40, none. 41, none. 42, we've discussed. 43 was agreed. 44 we've discussed. 45 and 46 are conditions related to borough pits. So does 47, 48. I think we won't deal with the Rothes borough pit question just now. Well, we can leave that for discussion of the Rothes conditions specifically. 49 deals with the two properties that can be converted. 50, again, back to the noise at borough pits. Yeah, there was a minor point here, just from the schedule of mitigation. It refers to keeping neighbours informed of the work schedule during construction. I assume there wouldn't be any difficulty if I added in some requirement along those lines to reflect the schedule, or is there any concern about that, or is that in there already?
I'm very happy with that, sir.
Right, okay. 51, that's relating to the noise of the substation bond, that's agreed. And 52 we've discussed. 53 is the shadow flicker scheme. Again, Rothes is resisting a similar condition, but we can discuss that in relation to the Rothes conditions. Then we've got the definitions, and I said that I would introduce a definition of first commissioning in the same terms as the Rothes condition, if that's acceptable.
Yes, we've looked at that definition, sir. That's absolutely fine. It was just an omission on our part. It should have been in there.
Okay. And that's it. There are some informatives. I have to say, it's not normally the style of Scottish Minister to add informatives to permission, generally speaking. So while I'm sure that the applicant, if permission were granted, would take these matters into account as put forward by the council, I think probably ministers wouldn't add these to any consent. But I think that's something for them. Right. So I think that deals with Clash Gour.
So just before we move on,
yes, absolutely.
There was two matters that you asked me to look at this morning. The first was in relation to a condition requiring a bond. And if you felt that the planning authority's justification for that was adequate and you wanted to impose such a condition, then we have prepared one and submitted it through the programme officer. It's based upon the Rothes 3 condition, albeit with the correct referencing in to link to our decommissioning condition.
Right.
So that's with you. I'm not sure it's necessary to go through it. It's in the same terms, effectively, as the Rothes 3 one.
Grand, okay. And has the council had an opportunity to look at that? Good. And you're content? You don't have anything to add? Okay, good. Right. Well, I'll take a look at that, and I'll have a think about the justification. Thank you.
The second point that you raised this morning was in relation to monitoring.
Monitoring, yeah.
And
condition 27, wasn't it?
It was. Thank you. I'm content. We are content for you to add reference to. I think it says in the second sentence, the HMP shall include the mitigation and monitoring measures. Sorry, I'm suggesting that as an addition.
Oh, right, and monitoring, right. Okay,
yeah,
right.
if we add and monitoring. I think in our draft we had focused on mitigation that might then be informed by that monitoring as being delivered. But I'm more than happy to add the word monitoring there. It makes it clear.
I mean, I kind of accept that monitoring could be seen as mitigation, I suppose. Yeah.
I think that deals with your points from this morning.
Yes, there was one other point about I've noted down road bond from the council. Yes, it was just. What did I ask? I'd asked about any other permissions that had referred to road bonds.
We could email you references, but yeah, we have found other appeal decisions, such as recently as Lord Hill and Murray in 2019, I think it is, or 2018. I know it was 2000 and decision was February last year, which there was a condition regarding wear and tear agreements. So
right.
we could send that on to your.
I take it there'll be no objection to the council just forwarding that on to me. Is that okay?
Not from us, sir, no.
You'd agreed the condition anyway, so...
We had.
Yeah. Okay. Great. Yes, if you would do that, would be very helpful. Thank you. Okay. Well, that concludes what we were talking about from the Clash Gour conditions. I don't... I'm obviously, again... It's just possible that similar matters will come up, or matters that you might want to discuss in the Rothes 3 conditions might come up. So you might want to stay, Mr. Nesbitt.
I'd intended to do so, yeah.
Oh, that's
Thank
good,
you.
right, okay. Okay, so we'll move on to the Rothes 3 conditions, and what I suggest we do is we go through the original proposed development conditions and then deal with the alternative proposed development conditions if there are any sort of separate issues that come up there. Is that okay?
Yes, sir. The only difference is, I think, in respect of condition 7.
Oh, I can't quite. Could you pull it towards you?
Condition 7, I think, in respect of both OPD and APD condition tables of the.
And that's the condition that relates to the actual design of the proposed development, isn't it? That restricts the design. Yeah.
That's right. So the rest of the conditions are identical in each one.
And in just reminding me of the discussion we had earlier, the proposal was that the description of the alternative proposed development should refer to 29 turbines rather than 23, and then subject to then there would be the reference to the condition. Then the condition would deal with what could actually be erected.
That's right, sir.
Yeah,
yes.
Good. Right. Okay, I'm on the right page. Right.
So if I could just add that the deemed planning permission description in the APD also refers to 23 turbines, and that should also refer to 29.
Yes, that's what I'd meant. Yes, sorry.
Yeah.
Okay, right. So I'll propose we just run through them in the same way as before. So condition 1 relates to the duration of the consent. It's slightly longer than Clash Gour, but I don't think that's an issue to do with that's the environmental impact assessment, what's being proposed. So I don't think there's any particular problem in there being a different duration there. Condition 2, just in. No, that's fine. I don't have an issue there. Condition 3, I don't think there's anything there. The non-assignation condition standard. Condition 4, yes, we'd said 24 hours. That's fine. Condition 5, radar mitigation, that's fine. Condition 6, I've got a couple of notes on this. The first is, why is the aviation lighting condition amongst the Section 36 conditions rather than amongst the deemed planning permission conditions, which is where it is with Clash Gour?
Indeed, sir. The condition has been put into the Section 36 consent conditions on the basis that the MOD's model condition that they required to be imposed asks that the matters be referred to Scottish ministers rather than the planning authority.
Okay, right, I understand that. There's slightly the terminology. I think there's a reference to undertaker in the condition. I take it would be fine if that was changed to company, which I think is the defined term.
Yes, a company is defined in the definitions at the end of the table, so that would be fine.
That's grand. And I wondered whether, obviously this is a particular condition put forward by the Ministry of Defence and Civil Aviation Authority and the Ministry of Defence. The proposal is slightly changed so that it's only, I think, 8 visible lights now. But of course, I was wondering whether a limit should be placed on the number of visible lights, but I suppose EIA has been done for more lights on the development than that. So I'm sorry, I'm wittering. I'm just going to pass over that because I think that's fine. Right. Well, perhaps I better ask: would Rothes 3 find a difficulty if a limit were placed on the number of lights reflecting their current position? That there should be, I think it's 8 lights, isn't it?
Yes, sir, it's 8 lights for the OPD and 5 lights for APD. We wouldn't have difficulty other than I'm not sure that it's absolutely necessary. The latest response from the MOD about lighting is included in the bundle. I think it's 15.2.1. The appendix includes reference, the response from the MOD on the lighting scheme. The EAIR has assessed the full lighting of all turbines over 150 metres.
You've essentially no interest in having more lights than you're required to have.
Absolutely not, sir, no.
Okay, right. Condition 7. Sorry, I've got a couple of scribbles, but I may not have a point to raise. There's a reference in italics in the second column to an amendment. Is that text passé now, or I just don't understand what it means in relation to condition 7?
So there was a requirement from Murray Council to include the details of the power rating, sound power levels and tonality and noise limit assessment required as a separate condition. If you feel it's necessary to impose that, we were proposing that it just be included here as part of the general description.
Right. Okay. Yep. Oh, I see that. That's the part in italics in the condition itself.
That's right.
Right. Okay, I'm there. Right. Okay. Is council content with that approach? Yeah. Okay. Good. Condition 8. It was, well, it's a very minor point, but the condition is no development shall commence until, this is in relation to sort of the ancillary development, substation building, associated compounds, foul drainage provision, water supply, and so on. Is it right to have a condition that prevents commencement of development entirely, or should it just be commencement of development of those particular items that are to be approved under this condition? I'm looking to, well, the council, I think, yeah, Mr. McPherson.
Yes, as long as it was suitably suspensive that it could relate to that particular element alone.
Okay, that's grand. Yeah. Micrositing, that's the next condition, condition 9. I just wanted an explanation. I know this is an agreed condition again, but I just wanted an explanation of that second point, that second bullet point. No development shall take place until a finalised post-consent layout is approved in writing by the planning authority in consultation with SEPA. I was just wondering about that, because does that... It seems to me that that rather defeats the point of micrositing. That I don't really understand how these things are done, but I'd assume that when you find out during the construction of the project where it's best to microsite the infrastructure too. But I'm willing to be corrected on that. If you have to get a final position before you start, it makes it rather difficult to address problems that come up as you go along.
So the particular wording of this condition has been included to address the concerns of SEPA, which enabled them to remove their objection.
That was in respect of Pete. Yeah.
That was in respect of Pete, and that is if the supplementary information that was submitted in March 2020 includes proposed micrositing of turbines to demonstrate that they could be microsited out with the deep peat areas. However, SEPA have agreed that that is possible and they're happy with that, but they accept that it may well be that there are, as site investigation work continues, that there may be alternative optimum specific locations for the infrastructure within the micrositing allowance, which was not described in that SI material.
So it's just a matter of obtaining SEPA's consent as you go along, or rather the Council's consent in consultation with SEPA.
Yes, that's right.
Right. Well, no one else has raised this, so I'll pass over that. That's fine. I understand where we're going. Okay. Right. So that explains a question I had in respect of condition 10. Hold on. Yeah. Yeah. Okay. Habitat management plan. This is another just a minor point, but it requires consultation with SNH, SEPA, and RSPB. Now, in general, it's not ideal, I think, to have a requirement for consultation in a condition simply because the planning authority can consult who it wants, and it's not really enforceable. It's just I suppose it's a record of what's expected, but we'd be concerned about a requirement to consult a non-statutory body who's also not a neighbour or anything like that, in the shape of the RSPB. I know it's the Council's requirement.
Part of the motive for asking those elements to be contained within conditions is just to reaffirm to the applicant an expectation that if we get consulted on such matters, you won't get instantaneous response. We need to consult these other bodies in regard to that. It also just means that if there's any challenge about how long we're taking to respond to compliance with the condition, and in the condition it's built into the condition that there's other parties involved, it makes it a bit more robust and defensible that we're waiting to hear back from SEPA.
I suppose SNH and SEPA know that they're to be consulted, yeah. Okay, right. But RSPB in particular, is it really appropriate to put RSPB in as a consultee?
I acknowledge they're not statutory. from memory, I think it's because there's elements of the habitat management plan, obviously, that touched upon bird ornithology. We just thought it appropriate to have their input, especially when it's matters that are very specific to capercaillie, etc. If that's required, that they would obviously have some input on that. You sort of don't have the expertise in that field, so to be honest, that's one of these things we would probably rely upon other bodies like SNH and to give us some input.
Right. Okay. Ms. Martin.
Yes, I think that obviously since this condition has been proposed and agreed with the Council, we've had the response from SNH confirming that they are perfectly content and very positive, in fact, about our proposed OHMP. And it may well be that now having had that and you have that in front of you, you might not think it's necessary to provide for consultation with RSPB because they are included within that OHMP.
Right. Well, we'll consider that. Okay. Thanks. Redundant turbines. Sorry, there's a point I don't think I brought up in respect of Clash Gour, but it's just a slight point of difference between the two arrangements. In this condition, there's a requirement to provide a scheme for removal of turbines within 3 months after the end of a 12-month period. With Clash Gour, it's 28 days. It's just one of those things. It's probably best to be consistent. So is 28 days acceptable for Rothes 3?
Yes, sir.
Great. Okay. Okay. Construction, environment management plan. This is where the issue about the borrow pits first emerges. So I understand that the proposal from the point of view of Rothes 3 is that borrow pits should be managed as part of the construction management statement. Is that sorry? But you better set out the position, Ms. Martin, as regards how you envisage borrow pits being dealt with.
Thank you, sir. This site is perhaps an unusual site in that it includes a number of historic and currently used borrow pits. There is reference in the, in fact, in the traffic STI that's at CD 15.7.2, Appendix B, which gives details of the use and extent of existing borrow pits, quarries that are on the site. So in those circumstances, as we set out in the noise technical paper that you have, we would say that the framework that we were proposing as set out in the proposed SEMP condition is perfectly appropriate to cover that off, and to go further than that is not necessary, and in fact could cause complications and difficulties because it only relates to the formation of borrow pits. And here we've already got a situation where there are existing borrow pits.
So essentially your provision reads the construction environment management plan shall include item C, details of borrow pit excavation, including excavation times and proposals to address complaints relating to blasting, noise and vibration. And that's your provision for borrow pits.
That's what we would propose, sir, to submit an appropriate scheme setting out methodologies for that, addressing those issues should they arise.
Mm-hmm. Okay. Ms. Thompson, sorry, Mr. McPherson.
It might be useful to get Mr. Caldwell to comment on these as well, because he was
yes, yeah.
partly involved in these.
Thank you, sir. I think the conditions we've put are the same conditions we put for Gour, and have just been heavily derived from the Scottish Government guidance on blasting, these prescribed times, limits, and we feel just gives a bit more certainty as to what's expected through the conditions, rather than having it placed within the Kemp, which has all sorts of other elements to it as well. And that's really it. They're quite standard conditions and limits and methodologies.
Okay, I mean, is there any particular problem that Rothes 3 would have if those standard conditions, or as in the Council's account, standard conditions were applied?
Not specifically, sir, other than the extent to which it's necessary to do that. We have Condition 17, which controls operating hours, construction hours, and we have the provision in the SEMP for the details of the workings of the borrow pits. And as I say, in this case, we have a situation where the existing quarries and borrow pits will be used. And indeed, borrow pits that are actually being used. However,
so just remind me of the significance of that. Why does that make it different? Because is that because they already have their own arrangements in place in other permissions? Is that where the issue is?
No, sir. It's just that there has been no issue. There has arisen no complaints, as far as we're aware, have been made about vibration or noise.
Okay, I think we understand where both sides are on that. Yeah. Right. Okay. Sorry, there were just a couple of things I'd noted that I couldn't see in there from the schedule of mitigation. One was marking off cultural heritage assets, boundary stones, with 2 boundary stones and an enclosure, and the other was water quality monitoring, which is mentioned in the EIR Chapter 10, I think. If those aren't covered elsewhere in the conditions, which they may be, I take it there wouldn't be any problem with adding those as items.
No, sir, no problem. Thank you.
Programme of Archaeological Works, which is agreed. Construction traffic management, which is also agreed. I think this is the condition from Transport Scotland, isn't it? I did have a question in that construction traffic is to use mainly the entrance from the A941. I just wondered if, there's obviously no condition restricting access from the C13E. I take it you don't feel that that's required? No, good. In the next condition is, I think it's just a slip in item D. There's a requirement for approval by Transport Scotland. I think that probably has to be a requirement by the planning authority in consultation with Transport Scotland, if we want to add that. Is that? Yeah, okay. Yeah. The next couple of conditions, construction hours, we've talked about that. Compensatory planting, we've talked about that.
Sorry, sir.
Oh, sorry. Yeah, Ms.
Sorry.
Martin.
Can I just take you back to condition 17?
Oh, yes.
This has now been agreed with Murray Council to address its concerns that it has in respect of. It's condition 4. It has what Murray Council call condition 4, which is at the bottom of the table. It's referred to in our noise technical paper, but it's at condition 4, which is page 11. So we've agreed that the condition 17 addresses that.
Ah, right. Okay. Yeah, I see that in the technical paper. Yes. That's fine. So that's not in dispute. Good. Sorry, just while we're on, so 18 is compensatory planting, but while we're on forestry, is any condition required on forestry management, treatment of forestry residues and aftercare, which are mentioned in the schedule of mitigation? But I may well have missed it in the conditions, but I take it you wouldn't have a problem with that being formulated into a condition if on review I don't find it. I'm sorry, I'm just wondering if I'm being completely clear.
Sorry, sir. Yes, I don't think that SEPA have not raised any issue about that. So if you consider it necessary and required to impose it.
It was just something, I was just on review of the schedule of mitigation. It seemed that hadn't been covered in conditions. And I think...
I would have concerns, sir, if there was any conflict with the OHMP and what is being proposed as part of that.
OHMP, yes.
I think that the relationship is quite delicately balanced.
Right. Okay. No, that makes sense. Yeah. Okay. Well, I'll have a look at that and see if there's anything that arises. No, I hadn't thought of that. Okay.
Thank you.
Right. Oh yes, condition 19. I don't know if there is. I rather like the arrangement of the Glashgar conditions on this, where I think it's condition 8. There's a clear requirement for removal of turbines from after the period of the permission has elapsed, and I think I'm not sure if there is a specific requirement for decommissioning, unless I've missed it in these conditions. I may have missed it.
No, sir, I think that does need to be included there. That's an omission. Yeah.
So if we simply added something along the lines of condition 8 of the Glashgar permission in the planning conditions, would that be acceptable?
Yes, sir.
Yeah.
Allowing for the 35-year period.
Great. Obviously 35. Yeah, 35 rather than 30. Yes. Yes. Okay. 20 we've talked about. 21 comes from the consultee. 22 we've talked about. 23 we've talked about. 24 shadow flicker. This is a condition agreed by Glashgar, but not agreed by Rothes. The Council's position is that shadow flicker effects do occur beyond 10 rotor diameters. I have to say that's not. I mean, it's not something I have any expertise in, obviously, but in the Scottish Government online planning guidance, it does refer to 10 rotor diameters as being the distance at which, I can't remember exactly what it says. I think it's where there's, yeah, but it does seem to suggest that shadow flicker doesn't really occur beyond 10 rotor diameters, but that's not the Council's experience.
I think it's our experience, and I'm not applying any hard science to this, but our experience is we've noticed, partly because of how far north we are, at particular times of the year when the sun is very low in the sky, in the west and northwest, and especially when a turbine is elevated above receptors, that 10 rotor diameter, I would suggest, can be breached. Now, I'm not applying any specific examples to that, but having observed that occasionally with other structures, the request for that condition really is just a precautionary request, but just to have that mechanism in place. But it's notable that sometimes that 10-metre rotor diameter does become an issue, especially where turbines, especially the height of some of the turbines that are proposed, and if they're quite significantly elevated above any receptors, and without pretending to bring any science to that 10 rotor diameter can be breached. And therefore that was just a reason for requesting that there be some mechanism in place in the consent that should occur. I'm envisaging, if there's any properties to the east of the property that you might think aren't within 10 rotor diameters, that might be subject to that occurrence at very low sun in the sky situations at certain times of the year. It's unlikely, but we think we want to have a mechanism in place to address it should it occur.
Do you have any particular property in mind?
Again, this is just again without applying any science to this, envisaging certainly for the submitted Rothes scheme, where you have properties that were 2-3 kilometres to the east, some that are referred to the noise conditions. They do sit sort of 3 o'clock to the wind farm, and they're just particularly for the submitted scheme, the taller turbines at the southern end of the scheme. If the sun were particularly low, we're just worried in case that phenomenon could occur. But again, it's just really just to make sure that, it's quite often the case that for wind farms, a particular element or a particular feature or a shadow flicker, which is areas you don't think it would have done. So it's really just a precautionary condition, so that if that were to occur in properties, usually to the south east or east of a wind farm, that can be addressed.
I'm sorry, I'm being stupid. There's the rotor diameter here is what there's 75-metre blades. Am I right about that? I think it's something like that, isn't it? So 150, so it'd be a kilometre and a half, wouldn't it? Even with 10.
Our only thought is, for example, obviously one of the factors that would come into play there would be elevation. I don't think for that general rule of thumb for 10 rotor diameters for wind turbines, it doesn't take account of elevation. Obviously, a taller obstacle casts a longer shadow, and if the turbines were at the same level as the obstacle or as the receptor, then maybe that would be more consistent. But it's just a thought that the turbines are probably geographically higher than some of the possible receptors. Again, I'm not pretending there's any explicit examples, just to make sure there's a condition in place that in the event that we do get shadow flicker occurring, that we have some mechanism to deal with it. Otherwise, we'll have nothing in the consent that allows us to deal with it.
Ms. Martin.
Sir, just to say that as there was nothing within 10 rotor diameter, no properties within that, it was scoped out of the EIAR, and no issue was raised at that point by the council as to the need to take into consideration properties that may be slightly, which were beyond that, but that were considered to be at risk of shadow flicker. So we would suggest that it's not necessary.
Good, thanks. Well, I think I've got both parties' position. There's then a condition on access plan, and I think that takes us to the end. Yes. Oh, sorry. We just had a stupid question on the definition of bank holiday. Why is New Year's Day? Why is a Saturday not relevant? Only a Sunday. That's on page 15.
I'm afraid I don't know, sir. Sorry.
I only recall there being debates about bank holidays, not for obviously the developers here, but a big argument with somebody this year about what's a bank holiday, and the bank holidays differ in England from up here. So that did cause a lot of problem about bank holidays. But it's better to have them specified.
Oh, well, okay. I'll maybe have a further think about that and see. It's presumably taken from a style, so it maybe does make sense.
So I think it might be because if it's a Sunday, people will generally not be working. Historically would not be working, so they wouldn't need the bank holiday on the Sunday, but they need it the following day, Monday.
Yes. Yeah, but I mean, the bank holiday wouldn't normally fall on a Saturday either, would it? Or the New Year's Day holiday. It's not. I don't think it's vital. I'll have a further think about it. Right. The alternative proposed development. Now we've spoken about the description, and the only other difference is in condition 7. Is that right?
Yes, sir. Yes, sir.
Right. Okay. So, unless anyone's got anything else to raise on Rothes 3, I think we're finished the conditions on that. Is that anyone got anything else to raise?
I think it's a no from us, sir.
Oh, okay, right, grand. Nope. Good. Okay, well, thank you very much, everyone. It's always the most exciting session of the inquiry, this session. So I'm glad everyone enjoyed it. So we'll reconvene on. It's now on Tuesday at 10 o'clock. Next Tuesday at 10 o'clock. Yeah, just to mention, Mrs. Black and I will be carrying out site inspections over the next couple of days, and that will include a site inspection at Rothes 1 and 2, and also Rothes 3. So, thank you very much, everyone.
Thank you, sir.